Good morning, everybody. Happy Thursday? Yeah, it's Thursday. Welcome to the Courtroom Files Live. Good to have you here. We will start our day with Judge Simpson, where undoubtedly Bond will continue.
Okay. Wow. Okay. I'm going to get better at this.
You're going to do great.
Miss Feltes, with the waiver.
Good morning, Your Honor. Ashley Bondi Feltus for the people. At this time, people would waive the copy of this honorable court and the office of the public defender. People do not believe that any conflict exists. Make waiver for the avoidance of all doubt.
Okay, thank you. I'm not going to get it.
I know.
I'm just not. I'm just letting you know. Go ahead.
Good morning, Your Honor. Intern Malika Fatima requesting to practice under MCR 8.120 under the supervision of the Deputy Chief Public Defender, Lauren Brown.
Permission to practice is granted.
Thank you, Your Honor. We do not believe there is any conflict between this honorable court and our office, and if any conflict is to arise, we waive that conflict so that this honorable court can hear these matters.
Seriously?
All them last.
The court also, thank you, counsel. The court also does not believe that there's a conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case People of the State of Michigan versus Alicia Carvin.
Judge? Morning, I'm Rob J. Tool on behalf of Ms. Cargill, Judge. I believe she's at the Huron Valley.
Cargo, can you state your name, please?
Alicia Cargo.
Thank you.
Your Honor, I was just appointed a couple days ago. I'm asking for at least a 2-week adjournment. Ms. Cargill, I'm going to make an arrangement to come out and see you at the Huron Valley.
Okay. Is what, the 14th? 4th. All right. Probable cause conference will be adjourned September 4th, 2025, 9 a.m.
Thank you very much.
Bond will continue.
Thank you.
Thank you. Thank you, Ms. Cargill. Court does call the cases of the People versus Dale Miller.
Andrew Childers appearing on behalf of the people.
Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Deputy Chief Public Defender, Lauren Brown.
Practice is granted.
Thank you, Your Honor.
Mr. Miller, can you state your name, please?
Dale Miller.
Thank you. All right, what are you doing?
Your Honor, the court should have received a competency report finding Mr. Miller incompetent but restorable. So we asked to adjourn this matter to allow him to continue treatment.
Are you talking about the August 4th?
Yes.
Court has looked at that. All right. Is there any other evidence for either side? The report finds the defendant is still incompetent to stand trial, but has the likelihood of gaining competency within a statutory period. I could have 90 days out. I will then adjourn the competency hearing to said November 6th for review November 6th, 2025. 9 a.m.
I did have one
Yes, sir.
comment with respect to bond. The victim in the stalking case is continuing to receive harassing phone calls from the jail for Mr. Miller. She did contact the jail and asked to have her number blocked through Securus. That apparently isn't working because the calls are continuing to go through. So the people would be asking to have Mr. Miller's phone privileges revoked.
Any response?
No, Your Honor.
All right. The court will at this time order that the defendant's phone privileges are hereby ordered revoked. So, all right. Thank you.
Thank you.
Thank you. Court does call the case People versus Cyrus Wegbright.
Good morning, Your Honor. Amy Rice on behalf of the people.
Good morning. If it pleases the court, John Minnick on behalf of defendant.
Mr. Reiser, I'm going to have a bone to pick with you that I didn't find out certain things till after I left the docket, but we'll deal with that. We've known each other a long time, so I'll take you in private. I'll let you,
Okay.
go ahead. All
So,
right.
For purposes of the probable cause conference, I'd request an adjournment. I'm still reviewing the discovery. Some of it came in earlier this week when I was out.
Will September 4th work?
No,
Okay.
I'll be on vacation for 2
11.
weeks. I'll be on vacation for 2 weeks. First 2 weeks of September.
Oh, the first 2 weeks in September. So September 18th? Any objection from the people?
No, Your Honor.
All right. Probable cause conference in this case will be adjourned to September 18th.
May we approach?
You have to, yes.
Yes, I have to.
Well, he's muted. Good morning once again, everybody. Welcome to the Courtroom Files Live. I have some exciting news for you today. As of this morning's show here on TCF is not just a video, it is also a podcast. So shortly after these shows end, they'll be processed, they'll be put up on the feed, and you'll be able to find this show now in places like Apple Podcasts, Spotify, what's that Amazon one? Audible, iHeart, all the places where you find your podcast, you will find it there now as well. So if you need a more portable audio only version of this show, it will now be available to you. So be on the lookout for that. The last 2 days are already up, and today's will go up as well. And happy to bring that to you. Yet another way to enjoy the show. So it looks like he's going to be a minute. So in the meantime, let's go see how Grumpy Pants is doing this morning.
So they stopped him. He says, "Why am I being pulled over?" And he goes, "I'm not being pulled over," and proceeded to drive away. After a short distance, he pulled into a parking lot by 163rd Street and Northeast 35th Avenue. He gets out of the car. They stopped him in an unmarked vehicle where they had the emergency lights on. He bladed his body, faced the deputy with both fists balled up. So that's with violence, I guess.
Well, Judge, he didn't threaten anybody, didn't swing at the officer.
He should have been charged for fleeing.
Bleeding his body and balling up his fists. I think that would be enough for
All
us.
you had to do was stop your car. All right, he has no priors. So count one. I don't know if there's probable cause, maybe assault to a law enforcement officer, a misdemeanor. Count one is probable cause for assault to a law enforcement officer. Count two, there's probable cause for resisting without violence. Do you see priors for him anywhere?
Nothing I'm aware of.
Right. Pretrial services alternate bond. Count one would be $1,000. Count two is $500. Next time, stop your car and deal with it. Everybody gets pulled over. It's not fun, but you do it. You don't get taken to jail. Have a good day. The next one, please. Corrections, give me the numbers you have, and we're gonna pull them out of turn, please.
27, Luis Flores,
Oh,
page.
that doesn't matter. Our calendar is not numbered right. That's the issue. Who's the next person, please, and what
Luis
page?
Flores, page 9.
Thank you. Luis Flores, page 9. And let me know when the private lawyer cases are here. They're all sitting here waiting. I'm sorry. Luis Flores, page 9. Good morning, sir. Do you speak English? I can't hear him.
Yes, Judge.
Thank
Sorry.
you. Good morning. Sir, you were arrested for possession of cocaine. I will appoint the public defender's office for you. So he was arrested on a bench warrant. He had 0.5 grams of cocaine in his wallet. Unfortunately, you're out on felony bond. There's a hold for F 25-11671. And I'm going to set your bond at $1,500. Have a good day.
Looks like Judge Simpson might be back. Let's take a look.
Lenawee County, they are testing her 2 days a week. Her father lives in Lenawee County with her 18-year-old son. She could be released to live with her father. She will follow whatever the court lays out for her to do. She wants a chance to make up for the fact that she missed appointments, missed dropping. Committed to doing this. I've warned her that if by any chance she gets out on bond out of this court, and if she steps even near the line, she'll be back in and it won't be any chance for her to get out. She has 4 children. The youngest is 18. She works as a painter and a landscaper. One would hope with strict conditions she could get out.
Response from the people.
Your Honor. She absconded while on a scram tether event in the beginning of July. Dawn was denied that she was free. I leave it up to Your Honor.
I believe that might have been her husband. My client informs me. And she's not been on a scram tether.
The note I have is that her case prior to this case, she had absconded on a scram tether.
Yeah. And then that I was aware of, but also on this case, particular case, she didn't do her drug testing and then didn't appear in court. So I mean, I don't know what assurance I would have that she would come back to the court. She did that. How did you end up back in custody?
I got picked up for drug charges
In Lenawee County.
in Lenawee County.
She has an open case in Lenawee County.
So you got picked up there. You didn't turn yourself in, even though you had been
I didn't.
testing and the court date.
I was on my way to turn myself in.
Oh,
I'd hired an attorney.
taking the scenic route.
No, I wasn't taking the scenic
No,
route.
no, she hired me, so it's definitely not the scenic route. She'd like another chance.
I don't have a problem releasing her to inpatient treatment, but I'm not just releasing her. So I would sign an order that the parties can stipulate to for release to inpatient treatment. But just to release her back out, I'm not doing that. She's not done anything, was not going to turn. She still would not be here if that warrant hadn't been out. She didn't come a volunteer.
Hired you.
Not to argue with the court, of course, but she was intending, she hired us and she was intending to turn herself in, but Lenawee County got in the way. That is what I've been told. And I do know that she did hire us.
I didn't know that I had the warrant for Lenawee County, Your Honor. I was picked up on it they came to my house. I didn't fight them. I complied with everything. I just would like to be given the chance to show that I'm clean.
Inpatient treatment, I'll release her in a PR. So council can
Yeah, I'll go
action in order
inpatient.
to that respect, but I'm not just releasing her out. She has
Got it. I know.
court's trust to do that. Motion for bond reduction or change in conditions is denied.
Talk to you in the back. Thank you.
You're welcome. The court does call the case of People versus Gregory Sistra.
National Law of People.
Which case is this?
Can't.
Oh.
Stephanie Cannon on behalf of Mr. Trunk.
We all knew that long before you showed up. Go ahead.
Yes, Your Honor. I am asking for an adjournment. I have a green sheet. As the court can see, he is in hospital. When I tried to go see him, I was informed that he was. So I have not had the opportunity to discuss this case with him. So I'm asking for a 2-week adjournment, Your Honor.
Oh, okay. You want the 28th then?
That is perfectly fine.
I have that date correct. That's correct. Probable cause conference, September 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, Mr. Sistro.
Thank you.
August 28th. I meant August 28th. Did I say something? Honest, well. Court calls the case, People versus Richard Halstead.
Andrew Childers, appearing on behalf of the people.
Good morning, Your Honor. Brandon Bird on behalf of Richard Halstead.
I'm just hiding over there or what?
On this official morning, Your Honor. Yes, Your Honor. Mr. Halstead, can you please state your full name for the record?
Richard Lee Halstead Jr.
Thank you. You're requesting an adjournment in this case?
Please, Your Honor.
Without objection, September 4th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Calls case of the People versus Kevin Davis. Yes, sir.
May it please the court, George Lyons on behalf of Mr. Davis on both files, Your Honor.
And good morning, Your Honor. Amy Reiser.
And seeing you, Mr. Lyons, it does please the court. How are you, sir?
Your Honor, it is always a singular pleasure and honor.
Okay, what are we doing?
If I may, Your Honor.
Yes, sir.
I have two issues. One is that we were just retained. We're still receiving and reviewing discovery. We're going to ask to adjourn this matter. We're also going to ask the court to consider a bond reduction.
All right.
We are opposed adamantly to a bond reduction.
Okay, I'll hear argument in a second, but how much time are we looking at in terms of?
Your Honor, I'm tied down on the 4th. I'm asking for the 9/11 date.
All right.
I've been listening from the back, Judge.
Probable cause will be adjourned September 11, 2025, 9 a.m.
Thank you.
As to bond, go ahead.
Respectfully, Your Honor, these matters arise out of allegations of inappropriate contact with students whom he was the track coach back in 2016, 2017. My client moved with his wife and family to Florida in 2019. People are alleging that because he lives out of state, he might be a flight risk. Let's look at the facts. From reviewing what I have so far, not only did they know, the police called and talked to him in Florida. He gave them his home address. He gave them his work address where they came and arrested him. His family lives in in Albion, where they have for the last 50 years, where he was raised. And we asked that he be allowed to bond out to the Adrian address in Calhoun County. He has no previous juvenile nor felony record whatsoever, Your Honor.
Response.
And Your Honor, this case involves multiple victims that the defendant had contact with and sexual relationships that he developed through his employment at the school. So he exploited these victims. He ended up having a child with one of them. He had to be extradited from the state of Florida. We requested a $100,000 cash or surety bond. The magistrate set it at $50,000 cash or surety on each file in order not to leave the state. We do believe that he is a flight risk, so I don't see any reason to release him on a versus bond at this time.
Your Honor, may I correct one thing that she said, or rather explain?
I hope it's about the child.
Yes, it is.
Okay, go ahead.
The child was born when the mother, at age 21, followed him to Florida and had their first child. They had their second child last year when she was 23 years old. So this isn't a part of the underlying body of the allegations, Your Honor. It sounds bad when they put it to you like that. But this child wasn't born out of any activity or contact or allegations when the child was a minor, nor when he was her track coach.
The relationship started when he was your track coach.
That's what I'm,
At Lincoln.
that's what I'm asking. I guess I was gonna ask. The relationship started there. The ultimate culmination, which may have resulted in the child,
7 years later.
happened 7 years later.
Yes.
But the relationship was while he was in a position of an educator over this child.
That is the allegation. Yes, Your Honor.
Motion for bond reduction, considering all of that, motion for bond reduction is denied. I think the bond is set appropriately, if not, quite frankly, too low, given the circumstances, at least as the court understands them now. So at this time, his bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus, is it Syntasia Callaway?
And is that on behalf of the people, Your Honor?
There you are, Rob Jacob on behalf of Ms. Callaway. Ms. Callaway, before you state your name, please.
Tasha Calloway.
Judge, I was just appointed on this matter. She and I just met this morning. I'm wondering if we could have the September 4th date at the adjournment.
You guys just met this morning?
We did.
Did you like it?
I do.
We did.
You?
We have a great going to
Yeah.
lunch.
Probable cause conference, September 4th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank
All
you.
right, thank you, Ms. Bell.
Let's go home and talk real quick.
Court calls case people versus Dalmatian Osman.
Yes, Your Honor. Brandon Bird on behalf of Mr. Osman. Mr. Osman, can you please state your full name for the record?
And good morning, Your Honor. Alex Warren Green. I'm standing in for Mr. Douche in file 1031.
Both of you are requesting an adjournment.
Correct, Your Honor.
That's correct.
28th work.
28th work, Your Honor.
Sure.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case as people versus Shanice Greer.
Ashley Lonnie for the people.
Mr. Douche is here. Why do you have to step in for you?
I ran out.
Hi, I'm here.
Judge, good morning. I'm Robert J. Colombo. I have Shanice Greer. Shanice, would you state your name for the record?
My name is Shanice Greer.
Thank you.
Judge, Shanice, as you know, is in recovery court. Judge Kunke's recovery court. This is a new possession case. I thought she was going to be here this morning. I've spoken to the prosecutor. I'd like to waive. Shanice, is it okay if we waive your case to circuit court so it can be part of the recovery program?
Ms. Greer,
Yes,
your attorney's asking whether or not you wish to waive your preliminary examination, move this case to circuit court so it can be part of the cases that you have before the recovery court.
yes, that is fine.
Is that what you want to do?
Yes, sir.
Okay, you understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
All right, you understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
All right, people also waive their right.
Your Honor, we will waive, but there is no agreement for treatment court and there's no guarantee, just for the record.
We'll work that out.
Right. I think Mr. Killawall was trying to just
Yes, Judge.
get everything
In
together.
fact,
in one
she's
spot.
due in recovery court at 11:30 this morning.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Mr. Killawall.
Acknowledge receipt of the information. We would waive. My client would stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
October 7th at 1:30.
October 7, 2025, 1:30 before Judge Gunky.
Thank you. Shanice, I'll see you at 11:30.
Bond
Thank you.
continue.
I hope.
It's my birthday.
What did she say?
I have no idea. She said
Thank
it's her
you.
birthday?
Happy. Okay, I'll
Is
see
it
you.
your birthday?
Yes.
Well, happy birthday.
Thank you.
You want the courtroom to sing to you?
Huh?
That's not gonna happen, but I thought I'd at least ask. Thanks.
Thanks, Judge.
Court calls the case of the people versus Sherry Walker.
And yes, Your Honor, Brandon Bird on behalf of Sherry Walker.
Mr. Bird would say.
Walker, please state your full name for the record.
Sherry Walker.
We're asking for adjournment today, but I'd also like to address bond, Your Honor.
Probable cause conference without objection will be adjourned August 28, 2025, 9 a.m. All right, as to bond.
Well, August 28th, I don't need to address bond because you're in down Farms line 2,
Yeah.
correct? No need to address bond then, Your Honor.
Okay, good.
Right.
All right, bond continued.
Your Honor, request, great.
Court calls the case, people versus Adam Bowman.
Andrew Childers, appearing on behalf of the people.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Adam Bowman. Adam Bowman, could you state your name for the court?
Adam Bowman. All right.
Your Honor, at this time, there's been no offer extended. We do believe discovery is complete, so we're respectfully requesting a preliminary examination date.
People have their witnesses available August 26th. Preliminary examination will be set in person August 26, 2025, 9 a.m. That is before Judge Washington. Bond continued.
Thank you.
Thank you.
But you're going to address
Oh,
bond.
I'm sorry. I'm sorry, Your Honor. He did want me to address bond. I apologize. May I address bond?
Yes.
I'm sorry. So Mr. Bowman is only being held on this case. He does have other cases pending, but he does have a personal bond in those cases. He is extremely concerned because he's in WCCC and his semester finals are supposed to take place, he indicates, next week. And he's very concerned that he has a Pell Grant, and if he's not able to complete his finals and complete his courses, he's concerned about the implications in terms of his further education as well as his Pell Grant status. He really is highly motivated to continue his educations. He's willing to do a GPS tether. He's willing to stay away from the University of Michigan Hospital, which is where this allegedly took place. He indicates he does have a place to stay, and he would comply with any other conditions the court would impose.
Response.
You would ask that bond remain as currently set. The defendant has an extensive criminal history, including a prison term for accosting a minor for immoral purposes. He's on the sex offender registry. The facts in this case involve him being extremely threatening to staff at the hospital, exposing himself to staff, threatening to rape and kill members of a nurse's family, destroying hospital equipment. So my concern, frankly, is the mental state of the defendant to engage in that sort of behavior. I believe that he represents a danger to the community.
May I respond briefly?
Yes, you may.
So he is on medication now. Since he's been incarcerated, he has been seeing CMH here in the jail, and he indicates he is taking his medication and he is stable. And I asked him, would he follow up with CMH, or what would his plan be for continuing his treatment if he was able to be released? And he indicated he would follow up with CMH, or he'd go to Packard Health. So I think that's the biggest difference. At the time of this allegation, he was going to the hospital for a mental health crisis. And my understanding was he was not medicated or being treated. And that was in part why he was going to the hospital in the first place. And then the allegations took place at the hospital while he was seeking that treatment. So now he is being treated. He is being medicated. So I think I had a great meeting with him yesterday. It was very productive. And I think he indicates he's in a better position and better state mentally.
Well, the examination is to take place in approximately 12 days. I am disinclined to change the bond given the allegations that have been made. So most
Not guilty by reason of standing.
Righty then.
Motion
Bond reduction is denied.
Thank you, Your Honor.
Thank you.
So I'm all for people trying to improve themselves. And if this guy's got an extensive criminal history and now he's going to school to try to better himself, I can get behind that. But perhaps he's putting the cart before the horse just a little bit. If he's still having mental struggles, maybe we should get all that under control before we try to pursue a higher education. But let me know your thought in the chat. Let's change it up a little bit. Let's go say good morning to Judge McNally. Let's move down the street a little bit.
Material addition, Your Honor. Since he did the PSI interview, his doctor recommended that he be placed on Lexapro in addition to the Klonopin.
Okay.
So and he's, he'll have a picture of the medication for the probation officer to show that he has been prescribed, that he has the prescription filled. I just wanted to make sure that that's on the record so he doesn't have an issue with that.
So, you have a picture to show, he has a picture to show, or what?
He's gonna, when he comes down for probation, he'll have a picture to show the
I got it.
probation.
I got it. Okay. I'll modify the report in that aspect. So he's been prescribed Lexapro. Go
Yes,
ahead.
John. Otherwise, there's no additions, corrections, or deletions. And based on the facts of the case, Your Honor, I would indicate that I think the recommendation from probation is reasonable under the circumstances.
Sir, is there,
Court to adopt it.
and he has been going to AA, has he shown you that?
Yeah. Hold on one second, Your Honor. He's showing it to me right.
I need to know that he's gone at least twice a week since July 30, so he should have probably 4 at least on there.
He does have, yeah, he does have 4, Your Honor. I have him right here.
All right. Okay, good. Anything else that anybody wants to say here? Sir?
No, you know that he's a veteran, Your Honor. Was in the Marine Corps for 9 years and he received an honorable discharge.
Okay.
But that's in the report.
Right. Anything you would like to say, Mr. Lazarick? You know, you got to be more careful. I mean, I got an officer here telling them that you were coming right at them and they had to swerve out of the way. You got to be careful, son. Okay, 13 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment or home telephone number, you must notify probation. You have to report as directed. No alcohol, no controlled substances, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs and ETGs. I'm going to make it bi-weekly for 4 months. If you're clean, I'll then revert it to monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order that you continue to attend AA twice a week until you're in intensive outpatient treatment. Once you get in intensive outpatient treatment, you no longer have to attend AA or NA. Also, you have to attend the Victims Impact Panel. You also have to obtain and maintain employment, provide proof, and also serve 4 days jail credit. 1, serve 3. I'm going to let you serve those on the court work program. There's 3 days court work program, $35 a day for that, for a total of $105. I'm in order that you pay fines of $300, cost $250, $75 victims' rights fee, $50 justice assessment. So your fines and costs are $675, screening fee $60. For $735, you have probation fees of $260 for $995, and then you also have court work program fees of $105. Plus your cost of recovery of $150 for a total of $1,250. If you violate, your probation could be revoked. You could be incarcerated for up to 93 days. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that? Sir, I didn't hear a word you said.
Yes, Your Honor.
Okay. All right. Can he pay all of this today, Mr. Bulahanis?
He's not in a position to pay it today, Your Honor. Can he pay 150 today and be placed on a, payment plan? He doesn't anticipate.
Yeah, he's got 2 children. I don't have a problem. I'll tell you what, you pay 150 today and then $50, I'll make it weekly. Can you do that, you think?
Yes, Your Honor.
I'll start you, I'll give you a little leeway time, okay? I'll start you beginning September the 5th, all right? If you ever need more time on the payment, no problem, call the court, we'll go on Zoom. I'll be glad to give you an extension. I did not sentence him on the civil infraction, the PPT refusal. That's fines and costs of $225. I'm just gonna give him a day out in advance there, Mr. Bulahanis, so he's gonna have to incorporate that somehow. I'll just say this, pay this one by December 1st.
Okay, I'll let him know, Your Honor.
Okay? Thank you very much.
All right, do you want him to go to probation today, Your
Yes,
Honor?
yes. Just call over there, though. Make sure that he's not gonna have to wait around. 734-671-0201, 671-0201, extension 245.
Okay, I got it.
Thank you very much. Good luck.
Thank you, Your Honor.
David Daniel Bluebaugh, 25T645469. Which one is it? John, can you come here? Your name? Which one do you have, counsel?
It's a felony.
Okay. Daniel David Bluebaugh, I'm sorry. All right, sir, you're here for a show cause. You have the money to pay this?
I just started working.
Why did you put this off so long?
I haven't had a job for the last 6.5 months.
Can't just ignore courts like this. When can you start paying on this?
I can pay next Thursday. I'm paying
How much?
full amount.
You sure? I don't need you to pay the full amount. Can you get paid weekly or bi-weekly?
Bi-weekly.
You pay $75 bi-weekly, beginning August the 22nd, okay? If you feel like paying it ahead of time, that's fine, but just don't ignore courts like that. You got default fees, late fees, you don't need all that. Good luck, okay? Nicole Marie Mayros, 25T646047. So is the felony?
Just waiting on Brownstown.
Okay, you called him.
I did, Your Honor.
Good morning, how are you?
Okay, how are you, Judge?
Good, your name?
Nicole Maris.
All right, so she's gonna go, they're gonna go ahead and dismiss this. This is a no license, you got the dog, the animal license? Okay, you're all set, case dismissed, best of luck, thank you. Chelsea Leanne Eldridge, 25T645-759, A and B. Good morning, ma'am, your name?
Chelsea Albert.
Charged with driving while unlicensed. You're also charged with being the scene of a property damage accident. You have the right to an attorney. If you want one, I'll give you one. Do you want a lawyer? You sure? You gotta keep your voice up.
Yeah.
Okay. I'll go ahead and arraign you, and then I will send you to the prosecutor to discuss the case. Okay? If they don't give you what you want, you can come back and apply for a court appointed, okay? All right. On June 26 of 25, it is alleged that you did operate a motor vehicle on West near Lafayette and Trenton at 4:19 p.m. while you were unlicensed or without a cycle endorsement. It is punishable by up to 500 fines, 93 days jail, costs are all those. And then you have to leave the scene of a property damage accident, which is a 6-point violation. It's punishable by up to 100 fines, 90 days jail, costs are all those. Do you understand that?
Yes, sir.
You got to keep your voice up.
Yes, sir.
Did you sign the advice of rights and read and understand the rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights. Now, do you still wish to waive your right to a lawyer? Pardon?
No, sir.
You want a lawyer?
Sure.
I'm gonna enter a not guilty plea for you. I'm gonna give you a personal bond of $500. We'll set you up with a lawyer right now. Your bond conditions are you cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. Do you understand that?
Yes, sir.
Okay, good luck.
Have a seat, Howard.
All right, let's head down to Florida, check in on Wade Mercer this morning.
Know that you met him yesterday. If you please introduce yourself to Mr. Rico and make sure he can see and hear you, sir.
Buenos días, señor Rico. Yo soy Jonathan Córdoba. Le voy a interpretar esta mañana. ¿Sí me escucha bien?
Sí, sí, escucho bien.
Okay, yes, he can hear.
Thank you. Mr. Rico, good morning again. You're here for the charge of violation of probation.
Buenos días, señor Rico. Usted está aquí porque incumplió su libertad probatoria.
I want to ask that you listen to Mr. McDaniel with the Public Defender's Office, sir.
Voy a pedirle que escuche al señor McNally que está con la oficina del abogado de oficio.
Your Honor, I spoke to Mr. Rico in case number 24342MM. He's going to admit that he violated his probation. Understanding he'll be sentenced to 15 days jail, 7 days jail credit, and he's already fulfilled all the other conditions, including fines.
Está aquí el señor Rico en el caso 24342MM. Hablé con él, él admitió su culpabilidad, entonces está de acuerdo en cumplir 15 días en la cárcel con 7 días de crédito porque ya cumplió con todo lo demás que se le ha pedido.
Sí, sí, está bien.
I'm sorry, Your Honor, I didn't catch
What did he say, Mr. Rico?
¿Qué dijo, señor Rico?
Cordova?
Oh, que está bien, sí, está bien, está 15 días.
Yeah, that's fine. 15 days, that's fine.
And Mr. Mitchell's out agreeable with the state.
It is, Your Honor.
Y el señor Mitchell que está con la fiscalía está bien, sí, su señoría.
And Mr. Rico, is that the admission you would like to enter, sir?
Y señor Rico, esa admisión o culpabilidad, ¿eso es lo que quiere hacer?
Sí, me quedo a los 15 días aquí está bien.
Yes, those 15 days are fine.
Mr. Rico, I'm going to accept your admission that you violated the terms and conditions of your probation.
Señor Rico, voy a aceptar que está admitiendo que incumplió los términos de su libertad probatoria.
But based upon the amount of the terms that you did complete, I'm going to sentence you to only 15 days in the Jackson County Jail.
Y teniendo en cuenta de las partes de los términos que sí cumplió, entonces nomás le voy a condenar a 15 días en la cárcel.
I'm giving you credit for the time that you've already served, which is 7 days.
Le voy a dar crédito por el tiempo que ya ha cumplido, que son 7 días.
You may actually do a little less than the 8 days you have left, depending upon whether or not you get additional gain time from the jail.
Y quizás puede tener o cumplir menos de 8 días dependiendo de el tiempo que le dan ahí en la cárcel.
So there's no court costs and fines and no probation remaining.
Entonces no hay costos de la corte o multas que todavía tiene que pagar.
Do you have any questions, sir?
¿Tiene alguna pregunta, señor?
No, todo está bien.
No, everything's fine.
All right, sir. Wish you the best.
Ok, señor, esperamos que le vaya bien.
Gracias.
Thank you.
Thank you, Mr. Cordova.
Thank you, Your Honor. Have a good day.
You too, sir. We have Jonathan Beach up next. Mr. Beecham, good morning. Mr. Beecham, you're here because you've been accused of violating the terms of your state probation. Mr. Beecham, sir, the affidavit, I've got a copy of in front of me. It is a no bond warrant. Mr. Beecham, what I want to do is go ahead and get you a lawyer appointed if you're asking for one. Would you like to have an attorney appointed to represent you, Mr. Beecham?
Yes, sir.
I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel. He's going to tell you when your court date is and give you some information, and then we'll see if you have any questions. Your Honor, we're going to plead not guilty. Yes, to set this on September 2nd court docket, and I advised him, Mr. Green, to come by and visit him prior to that hearing. And Mr. Mitchell, anything from the state?
No, Your Honor.
Mr. Beecham, Mr. Green will see you before your court date. Do you have any questions, sir?
No, sir.
All right, Mr. Beecham, wish you the best.
Thank you.
Let me see. Alfred Bryant and Darian Works, please. All right, which one of you gentlemen is Mr. Bryant? All right, that means the other person is Mr. Works. So I'm seeing you at the same time because your cases are basically identical for first appearance purposes. Each of you has a hold from another county, and each of your holds has no bond for the time being. Mr. Bryant, your hold is out of Brevard County. It's a charge of violation of probation. Mr. Works, your hold is out of Washington County, and it's a no bond warrant also. So what that means is you're going to be held until you can get those two counties and get this cases resolved. I cannot tell you your transport date because I don't know. I can make a pretty good estimate. Mr. Works, Washington County is really close. You should be over there in the next couple of days. When you get there, you'll go to another first appearance, and that judge may or may not address your bond. Right now, you've got no bond. Mr. Bryant, because Brevard County is a little further away, I usually tell people 7 to 10 days. You're probably going to be in Brevard County in 7 to 10 days, and you also will go to another first appearance in front of a local judge once you get down there. Let me see if either of you have any questions. Mr. Bryant, do you have any questions?
No, sir.
Wish you the best, sir. Mr. Works, any questions?
No, sir.
Wish you the best, Mr. Works. Sarah Sizemore. Ms. Sizemore, good morning. Ms. Sizemore, you were being brought back tomorrow, but I think there's some more charges that have come in. Matter of fact, I know there are. Ms. Sizemore, you have 3 additional charges that you've been accused of. 1 count of uttering a forced instrument, 1 count of use of another person's ID without consent, and a felony petty theft for third or subsequent offense. So, Ms. Sizemore, there is probable cause on those new cases. I'm going to set you a bond on those, but you are coming back anyway, supposed to come back tomorrow to see if the state has filed information against you in a felony case that you have in Jackson County that has been pending for a while. And I'm trying to pull that case up. I believe it's going to be 25276 CF. I think that's it.
It is your.
No, that's the new possession control. Yeah, that is it, isn't it?
Yeah, that's it.
So possession control substance. So the court file, Mr. Mitchell, is still not showing information being filed. What's your understanding of what the status is of that case?
Mr. Gill was working on filing the information this morning. I just don't think it's hit the clerk system yet, but he is filing in information, and he's also adding a charge to that case for possession of paraphernalia.
Okay, so
what?
Okay, I don't. By direct information?
Yes, by information.
By direct information?
Yes.
I thought y'all stopped doing direct information. So. There's an email about 2 weeks ago that said y'all no longer doing direct information, so maybe exceptions to that. I don't know. So was there another case that I first appeared on?
It was a battery case, 25433 MM. Need to set a bond on it or.
Okay, and then there was also a urinalysis result after that first appearance that was positive for, according to what the jail sent me and y'all, was positive for methamphetamine and amphetamine.
Yes,
correct?
yes, Your Honor.
All right, so Mr. McDaniel, anything before I address those issues? Mr. Mitchell.
Let me double check the. Yeah, 25276. She was arrested on that one, so there's that at least. Back on the 6th or June 6th. But other than that, nothing. I just wanted to bring that to your attention.
So, Ms. Sizemore, here's what you've got. Did I set a bond in the new battery case?
No.
So the new battery case that I first appeared on is going to have a bond of $5,000 because you have a pending charge at the time that the new charge occurred. The uttering of forced instrument, the bond's going to be $10,000. The use of another person's ID is going to be $10,000, and the felony petty theft is going to be $10,000. So your bond in those cases will be $35,000. If I'm not going to revoke your bond at this point in 25-276 CF because the state still has not filed information against you, and I have no intent to revoke your bond if they're not going to charge you. If they charge you by the end of business today, I do intend to revoke your bond based upon the positive analysis as well as the arrest. So, Ms. Sizemore, we'll see if they charge you or not by the end of business. If they do, Mr. Mitchell, I need y'all to send me an order revoking her bond in 25-276 CF. Ms. Sizemore, we'll see what happens. So you don't have a bond right now. So she needs some definitive, she needs to know whether or not she's got a bond or not. The only way I know to do that is to bring her back tomorrow and let her know whether or not the state has formally charged her or not. Because she won't know otherwise, will she?
It's been way over the days.
I'm checking it right now. You mean checking your system? Please, yeah. So it hasn't been pulled over by the clerk's office. Ms. Williams' thinking is if the state attorney's office has filed it, this has not been pulled over. We can go ahead and answer that question now.
They said it hadn't
So
been
she's gonna-
filed as of.
Well, it's not in the statewide system, but if Mr. Gill is his case, right?
Yes.
If Mr. Gill has filed it, a deputy clerk has to then pull it over from the state attorney's office e-file system, and it may be stuck in limbo if it was filed this morning. So we're checking to see.
It's
if
over
state
the
has actually
days,
filed
ain't it? Still,
Ma'am?
it's still over the days, ain't it?
Ma'am, what that rule says is that at 60 days, you have the right to file a motion, and potentially at 63 days, the terms of your bond will go away and it becomes an ROR. There was no motion filed until Mr. McDaniel made that motion for you at your first appearance. So that's kind of where we stand. The state has filed information. This has been filed, Ms. Jackson. Okay. So the state has charged you with possession of controlled substance and possession of paraphernalia. So I wasn't involved in that. The judges weren't copied on that email that went out, that letter that went out to law enforcement about no more direct informations. So how is it not a direct information if she wasn't charged with the possession of paraphernalia to begin with?
I wasn't.
I don't think y'all can file an information, a regular information, if there's no complaint. If there's nothing to base it on. So
maybe the basis is inside the complaint.
I'm sorry.
Maybe the basis is in the complaint. They just didn't charge, the facts of the.
So the state, but the clerk's office can the clerk's office set up?
Yeah, usually charges when we file the information in the clerk's office.
Yeah, they usually amend them with the information, whatever the information says, they'll amend it to say that.
So I've seen them say, well, one counts a direct information and one counts a regular. So you think this is just a regular information?
I think that's regular information.
Is that charge controlled substance?
Yes, Your Honor. In the complaint we reviewed today, there was mention of when they found the substance, there was a folded dollar bill in there that contained some substances in it, thus giving probable cause to the paraphernalia.
So it looks like the state has filed a charge for what you're originally accused of and added a misdemeanor charge of possession of drug paraphernalia. So given that, they have done that, I am going to revoke your bond for the reasons I've already said. So even though you've got a new bond on some cases, Ms. Sizemore, you have no bond on at least that one case. Ma'am, let me see if there's any other conditions. I do need to put condition of no contact on the uttering use of another person's ID and felony petty theft. There are two different people you can have no contact with. One is the person you allegedly used their ID of. Miss Millwood was her name at one time. I'm not sure if it's still the name, maybe Smith now. The other person you can have no contact with is the person whose check was supposedly forged. Ms. Sizemore, do you have any questions? Have a good day, ma'am.
What was her bond in today's cases?
Be Real, thank you for becoming a channel member. Very much appreciate it. You'll enjoy this place, trust me. And I'm not just saying that because it's the place I run. This is a unique space on YouTube. One of our regulars here actually emailed me this morning to let me know that she was going to be busy at work for a couple of days and to let everybody know so nobody worried about her. And people would ask. That's the kind of community we have here. Very caring. Everybody gets along really well. So welcome. Let's go back to Judge Simpson. Let's see what's going on with him.
Ready for exam on this matter.
Yes, Your Honor. Discovery is complete.
People have their witnesses available on the 26th. Preliminary examination in person, August 26, 2025, 9 a.m. before Judge Barr. Bond will continue. Court does call the case People versus Isaiah Bozeman.
Andrew Childress, on behalf of the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bozeman. Mr. Bozeman, could you please state your name for the court?
Isaiah Bozeman.
Your Honor, we're asking to continue to exam. Discovery is complete.
Let's just put on the record that I will have amended complaints and information. Probably will be done by the end of today. At the latest tomorrow, adding corresponding felony firearm counts for the reckless discharge of the building. As soon as I have those will be sent to Mr. Bernstein and the co-defendant, Mr. Willis, who's represented by, I believe, Mr. Warren Green.
It's been a long week, Judge. Just make it till Friday, but okay, I'll keep an eye out for the email.
What'd you say?
So it's been a long week, but I'll keep an eye out for the email.
Okay. And they don't really change the substantive. They're just a corresponding felony.
I'll meet you and explain that to you later.
Right. Is the co-defendant in this case also setting bail?
I think so, Your Honor, yeah.
Your Honor, Alex Warren Green on behalf of Mr. Willis, the co-defendant. We are.
Okay. So, who is Judge Washington? Preliminary examination in this matter in person will be set August 26, 2025, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Bond will continue.
I'll sign next week, man.
Court does call the case of the People versus Logan Roberts.
Andrew Childress, on behalf of the people.
Sam Bernstein for Mr. Roberts. Say your name.
Logan Roberts.
And this case is ready for exam as well, Your Honor. Discovery is complete.
People have their witnesses available to 26.
That's fine.
Discovery being complete. Preliminary examination will be set August 26, 2025, 9 a.m. That's before Judge Barr. Bond continued. Court calls the case of the People versus Fred Willis.
Andrew Childress, on behalf of the people.
And Alex Warren Green on behalf of Mr. Willis. State your name, Mr. Willis. Fred Willis. Your Honor, we are requesting preliminary examinations in, Mr. Willis has two cases, so both cases.
In both cases?
Correct, Your Honor.
And could they be heard on the same day by the same judge, or what do you want?
I believe they can, Your Honor.
People have their witnesses available to 26.
That's fine.
This was said. This is co-defendant. I said that before Judge Washington. Preliminary examination in person August 26, 2025, 9 a.m. before Judge Washington.
Your Honor, I will just put on the record that Mr. Warren Green, I'm sure heard it, but for purposes of the record, the people are filing amended complaints and information. I expect to have them adding additional counts of corresponding felony firearm counts for the reckless discharge of an occupied building.
And Your Honor, that was relayed to me. I counseled my client accordingly.
All right. And again, as the court would indicate, it doesn't seem to me to substantively change the offenses, but, and so could be heard on that day.
Correct, Your Honor.
August 26, 2025. File continued.
Thank you, Your Honor.
Court calls the cases of the People versus Robert Gallett.
Morning, Rob J. Kowal, Your Honor. I'm on case 25 F5 5612.
And Alex Warren Green on behalf of Ms. Gallett in case 5713. Ms. Gallett, can you state your name for the court, please?
Can you hear me?
Yes,
We can hear you now.
Yes,
State your
sir.
name.
Just give me Robert Gallet, also known as Lynn.
All right, thank you. All right, what are we doing?
Your Honor, in 5713, I've completed a green sheet. We're asking for an adjournment to continue finalize our negotiations. I think Mr. Killawald is joining me in that request.
that's correct, Your Honor.
Can that be done by the 28th?
Believe so, Your Honor. Is that okay with you?
August 28th, 2025, 9 a.m. Bond continue.
Sure.
Thank you, Judge.
Thank you. Court calls case of the people versus Barrage Scott.
Stephanie Cannon on behalf of Mr. Scott. And Your Honor, we are going to ask for a 1-week adjournment of this matter to discuss, I guess, just some information with my client.
I don't have a week, so it's gonna have to be.
It's gonna have to be the 2 weeks. Okay, so we're gonna request a 2-week adjournment, Your Honor. Your Honor, my client would also like to ask if he could be released on home confinement tethered to his grandmother's house.
That we already addressed this.
I know, Your Honor. He's just whispering in my ear, so I'm just.
Well, I've already addressed that. I'm not releasing him on that. And for the reasons that I stated before, so I don't need a response. That's a request for a bond reduction or a modification. I think it is, that is denied. Probable cause conference, August 28th, 2025, 9 a.m. Bond continue.
Understand if the next talk to your grandmother, she'll talk to you about it, okay?
Court calls case People versus Keith Walker.
Good morning, Your Honor. Christina Costantino appearing on behalf of Keith Walker. Mr. Walker, can you please state your name for the court?
Keith Walker. Thank you. All right, what are we doing?
Judge, this is a date and time set for a PCC. I was just recently appointed to this matter, and this is my first PCC on this case. Given that, I would ask for an adjournment of the PCC to review discovery and have discussions with my client.
Without objection, would the 4th or 28th be better for you, Ms. Constantine?
Judge, the 4th would be fine.
All right.
Or, I'm sorry, Judge. Could I have the 28th? Sorry.
The 28th, all right.
Yes.
August 28th, 2025, 9 a.m. All right, sir. Thanks. Thank you. Bond continued.
Thank you, Judge.
Thank you. Court does call the case People versus Stephen Bauer.
Amy Reiser.
Good morning, Your Honor. Sam Bernstein, standing in for David Burgess with on behalf of Mr. Bauer.
Stephen Bauer, Your Honor.
All right, you have no objection to counsel. All right. You're requesting an adjournment.
Yes, Your Honor.
28th work.
Yes, Your Honor.
Without objection, probable cause conference, August 28th, 2025, 9 a.m. Bond continue. Thank you. Court calls the case of the People versus Amar Amadou.
know who this young man is. Thank you. Stephanie Cannon on behalf of Mr. Amadou, Your Honor. And Your Honor, at this time, my client is going to waive his right to, sorry, could you state your name for the record?
Amar Amadou. Walking all over the world.
I'm sorry. I'm sorry, Your Honor. My client is going to waive his right to a preliminary exam.
Is that correct, sir?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that here. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 following.
And Your Honor, at this time, we would waive formal reading and stand mute as to the charges.
Defendant never waived formal reading, standing mute as to all 3 counts. Court will enter a not guilty plea. Pretrial will be set for
October 6th at 1:30.
October 6, 2025, 9 a.m. before Judge Hamoud. 1:30, I'm sorry, before Judge Hamoud.
Okay, friends, before we continue to the next location, let's talk about the sponsor for today's show. You know them, you love them. It is Aura. Look, I've been very clear since the start of this channel. I will never recommend anything that I would not use myself. So when Aura came to me and said, we want to partner with the channel, I made them prove what they could do because I hadn't used them before. And I'm proud to say I'm actually now an Aura customer. Like it or not, our personal data and our privacy is it's out there, it's at risk, and we need tools to handle it. And Aura is one of the best, if not the best. I'm looking at my dashboard for Aura right now, and all of the companies that they've removed my information from, these online brokers of data, in the last couple of weeks. And the scary thing is these are companies that I do not recognize. For example, who the heck is Alesco Data or Altair or Buxton or Catalyze or Demist or Fetcher or IDM or IQVIA? I think that's how that's pronounced. Or LeadSpace or SageStream or Lime Leads or LiveRamp or NovaList or Persistent or Posty or SyncMe or BDO. That sounds like a band name. Or Blackbaud, or you get the idea. It's just, our stuff's out there everywhere. We don't even know where it is, and they've got it, and it's getting sold. And the beauty of Aura is they're finding things that I didn't even know existed. But the bottom line is it doesn't just stop with removing your data from online brokers. They have identity theft protection. They monitor your transactions for you. There's an antivirus. There's the VPN. There's spam call protection, which I've been very upfront with you has been one of the biggest things I've benefited from here. I was getting a dozen or more spam calls a day. I'm down to maybe 1 now since starting with Aura and having them help me with that. There's all sorts of tools that they make available to you, and the bottom line is it's a one-stop shop, and it is just a tool that works. Good news. Go to aura.com/TCF. They'll give you 2 weeks for free, 14 days, so that you can see what it will do, evaluate the product, and decide whether or not it's for you. You'll figure out within 24 hours everything they'll be able to do for you, because very quickly they'll find where your information is and they'll start the removal process. So I'm guessing that you'll choose to continue to be a customer, but you've got 2 weeks to decide, and it doesn't cost you a dime to do it. So you might as well. I mean, you have nothing to lose, everything to gain. And furthermore, it supports the company that supports the channel. So aura.com/TCF. If you're on the fence, get off the fence, give it a try. Trust me, it makes all the difference in the world. They're finding things I didn't even know existed. And that alone is, quite honestly, frightening, but I'm happy that I have them to fix it for me. So again, aura.com/TCF. Let's go to Louisiana. Let's see what's up.
Consider our next case, and that would be Mr. Steve Stewart. Mr. Stewart, good morning.
Good morning.
Would you introduce yourself for the record, sir? Tell us your name and DOC number.
My name is Steve Stewart, DOC number 337546.
Okay, and you have counsel with you. Counsel, would you introduce yourself?
Good morning, Board. Adrienne Hutchison, attorney for the Louisiana Parole Project, here on behalf of Mr. Steve Stewart.
Okay, thank you. We have quite a number of people here in support today on Zoom. We have the Parole Project, Mr. Myers, Mr. Reginald Watts, also on Zoom. Here at headquarters, we have Tara Raven, Stacy Polizzola, and Tim Wilkerson. At Hunt, this is who I have on my list: Carrie Stewart, Roy Waller, Ron Hicks, Keith Bozier, Gil Jasmine, Sydney Morton, and Mary Waller. Did I miss anybody?
No, ma'am.
We also have some folks here with us at headquarters in opposition. We have Stacy Bates and Stephanie Sanchez. And also of note, I have listed on my sheet that are not speaking, they're viewing, but have an interest, is Charles Degervels and Arthur Rhodes. So first, let me just put some information into the record. Mr. Stewart was originally sentenced in March 1994 to a life sentence for second-degree murder. His sentence was commuted by Governor Edwards in November of 2023. His sentence was commuted to 99 years with parole eligibility after attaining age 55. It's my understanding your 55th birthday will be July 15th of 26. Is that right?
Yes, ma'am.
So the reason you came up for parole before that date was because a different legislative act, Act 122, made you parole eligible sooner than your 55th birthday. Is that correct?
Yes, ma'am.
Okay. You had a parole hearing August 8th of 2024. You received 2 votes to grant, 1 vote to deny, which it has to be a unanimous vote. So that outcome was that your parole was denied at that time. And you submitted a request for reconsideration based on a technicality. And that request was granted. And that's why we're here again today. Is all that right?
Yes, ma'am.
Okay. So we've been through those preliminaries. Your case, well, first, let me ask Ms. Hutchinson, is there anything you'd like to say to us before we hear from those who are in support?
Just that you read Mr. Rhodes and Mr. DeGravelet's name towards opposition, but they are in support. So I just wanted to, okay. You know,
I said support. I'm sorry. It does indicate that they are in support. Thank you.
Yes, and I will speak at the end when the panel determines its approach.
Okay. Morton, is there anything you want to tell us about Mr. Stewart?
He's been housed in Elaine Hunt since 2019. He's obtained a level 3 minimum custody status. He's currently a lead mentor and he's housed in our VETS program dorm. His last write-up was in 2008, so he's been 17 years disciplinary report free.
And sir, I see Warden Turner has stepped out and we had his name recorded on the record. Would you introduce yourself for the record, sir?
Deputy Warden Luke Raines.
Okay. Good to see you, Warden Raines.
Deputy Warden.
All right. Could we hear from Mr. Myers, Kerry Myers with the Parole Project?
There we go. Good morning, Kerry Myers with Louisiana Parole Project. We want the board to know that we're here in support of Mr. Stewart. We've been in support since prior to his clemency hearing, through his first parole hearing, and now. And there are several reasons why. One is before you. I'm not going to go through all that. You have his extensive record. He has been incarcerated for 32 years. I believe just that, rehabilitation, and I believe Mrs. Stewart has shown that, starts with accountability and recognition of the harm that was caused. It also requires a desire to change and an action based on that desire. And Mrs. Stewart has done those things. And he's done it beyond what I would consider to be anything that would be minimally required of him. He's gone above and beyond. We're prepared to house and provide housing and support for Mr. Stewart, at least up until his 55th birthday, which is 10, 11 months from now. If there's any concerns about that, we certainly would be willing to keep him in our housing and in our program for at least that time. We would just ask the board to consider Mr. Stewart's rehabilitation, his remorse, the work that he's done, not only on himself vocationally and cognitively, but the work that he's done to give back to his communities through hospice, through Point Lookout, through being a leader and a mentor, everywhere he's been. So I'm not taking the board's time anymore. Just ask this board to grant his parole today.
Mr. Myers, here with us, we have the chaplain, Stacy Polozola. Would you like to speak? Would you step up to the podium, please?
Good morning.
Morning.
My name is Stacy Polozola. I've been at Elaine Hunt for 20 years. 18 of those years were as a volunteer, and the last couple were part-time as the Catholic chaplain out there. So part of my journey, though, that brought me to the Department of Corrections out at Elaine Hunt was my own journey as a victim of violent crime. So before I always agree to either speak and or like a letter of recommendation, I'm always looking at it through the eyes of not only my relationship with that person, but also through the eyes of what it must be like for the victim. You have the paperwork in front of you to see the accomplishments and opportunities that Mr. Stewart has taken advantage of during his incarceration. So, we're not going to go over that. But for me, what I also like to look at is how an inmate deals with disappointment, with bad news, a bad health diagnosis. And since 2014, I've watched Steve on multiple occasions when those have occurred. And he's dealt with them with much grace and integrity. His faith, has never in those moments wavered, and his spirit remains steadfast. So I guess in closing, if the state of Louisiana were to write a new curriculum on what rehabilitation would look like, Mr. Stewart would be a perfect example of what success looks like. He has a plan. He has done everything that he possibly could do to make the most of 33 years and 32 years. And I also pay attention to what time really is. In a few hours, we're all going to be looking at our watch because we're going to be wanting lunch, or we're going to be looking at 4 o'clock on Friday or the summer vacation. 32 years is a long time with the Department of Corrections, and he has made the most of what a person could possibly do in this situation. Thank you for letting me speak.
Thank you for being here. Mr. Wilkerson, would you want to say a few words?
Good morning, and thank you for giving me this opportunity. I can echo the statements that Ms. Funk was over made. I mean, Steve Stewart's record is in front of you, all of those accomplishments, but I've known him for a number of years, and I think for me, the reason why I've been before the board twice on his behalf is because he not only embodies rehabilitation, he embodies being the person that we all desire to be something. Despite the decisions that he made early on in life, he has given to the community in which he lives for so long. Any person that is willing to serve someone in hospital or hospital for 25 years, for me, that's an indication of your character. That's an indication of your love for mankind. So we can talk about all the things that he's done on paper, but his actions show. And just not long ago, a few weeks ago, I was talking with Steve, and I asked him the same question that I'm sure that you all may ask. I said, Steve, why do you believe that you should be paroled? What's your reason? I have my reason. I know why you should be paroled, but why do you believe that you should be paroled? And I'm glad his mother, Miss Mercedes Stewart, and other family members are coming in right now. I'm so glad that they made it here. They were trying. Miss Mercedes suffered from completing a heart attack. This family has watched Steve come full circle for 32 years. And so when I asked him, I said, why do you believe that you should be paroled? His words to me were, I want to be paroled so that I can serve my community. He didn't say so that I can rebuild my life, so that I can do this, so that I can do something for me. He still is maintaining that he wants to serve the community, and he has done that for 32 years. There are a few people that have the record, not on paper, but being a man of character and learning from his mistakes that I've encountered through my journey throughout the Department of Corrections and now beyond. So I ask this board to please consider granting his parole.
Thank you. Hey, Mrs. Stewart, did you hear that your mother was able to come into the room?
My mother, yes.
Well, we have some other folks that have joined us. Let's see, Olivia Dickinson, Mercedes Stewart, your mother, Asia Brown, and Richard Gardner. So you know. All right, Ms. Hutchinson, we'd like to hear your presentation now before we hear from the victim.
Thank you, committee. And before I start my presentation, I would like to acknowledge the Brock family that I know is present. I don't want them to think that any of the things that I say about the man that Steve is today is to diminish the hurt and pain that I know the family has felt. When you think about what a person being granted parole should look like and what their life should look like in their time in prison, I believe it's twofold. Because I think it's really the only way to gauge true remorse, and that's where it really starts. First, what has the person done to change who they are? Because if you're truly sorry for what you've done, then you'll do everything in your power to change from being that person. And then second, what has that person done to give back, to atone for their crime, and a crime that is so painful and hurtful as taking a life? You have before you the largest brief I've ever submitted, providing the depths of those two folds. And after speaking with classification this morning, I probably only had about half of his accomplishments, his work, and his volunteer work, because I think her packet was larger. And it's not that big simply because he's been incarcerated for over 30 years, but because of the consistent, constant, and real work he's done and continues to do, even after his denial last year. From being undereducated and entering prison with an 8th grade education, he has an associate's degree, a bachelor's degree, and hours towards his master's degree. He's hireable with vocational skills in HVAC, electrical, construction site management, and generator and engine repair. But this just shows that he's moved on from the life he was living and is educated and employable now. I think the second fold is the important fold. It's the dedication to remorse and the shame that comes with taking a life. It comes from wanting to put something back into the world that's good after causing so much pain. It shows the internal change that makes a person no longer a threat to society. And what that looks like with Steve is over 20 years in hospice care, both at Angola and at Elaine Hunt. It's coordinating the transition program. It's pastoring and ministering at his church. It's tutoring in the education department. It's mentoring in the residential drug abuse program, teaching in the transitional program, and being a walking role model with only 8 disciplinary infractions in over 30 years. And almost 30 classes that he's facilitated, mentored, or tutored. Steve is the whole picture of growth, education, humility, gratitude, change, and the profound remorse that he carries forever for taking Mr. Brock's life that led to these everyday actions. That's why his reentry plan is tailored towards the concerns that the Brock family said on his last hearing. He heard them. He will not be returning to the river parishes. It's outlined in the brief, those parishes. He will be with the Louisiana Parole Project till 55 to compensate for what the pardon board had requested, because we know the legislation takes precedence. But lastly, to grant Steve parole, someone who is a proven leader in behavior, teaching, and ministry, doesn't just benefit Steve, but the entire prison community. And I mean that beyond the walls of Elaine Hunt, because Steve's work with individuals you can see in all DOC institutions. His example of consistent integrity, personal growth, and service has inspired. And if granted parole, will continue to inspire others within the prison that the world sees their positive change. We acknowledge it, and that real redemption and rehabilitation, which we know to be true with Steve, can provide tangible outcomes. It's time to move Steve out of the way. Move him out the way so others can step up. Because people here know Steve's got it. He'll handle it. He'll teach it. Make way for others to move up into that spot. Give inspiration and motivation to others who aren't quite there yet, but look and see him every day on the wall. Allow them to walk in his footsteps as he moves on. He's ready, willing, and able to lead outside of this prison. He's inspired groups that come in all the time about the power of redemption and rehabilitation. And the many men that are here and present with you today are in this room because part of their rehabilitation came from Steve, whether it was as a mentor, a tutor, or a minister. So today we ask the board to see what all of them have seen in Steve and provide him a second chance with the guidance of the Louisiana Parole Project and any conditions this board and the family deems necessary. Thank you.
Thank you, ma'am. All right, now we'll hear from the opposition, and Ms. Stephanie Sanchez wants to speak.
Good morning, everybody. So I keep hearing, life, when you think about what we've missed, we're gonna focus on my brother for a while. He died at a very young age. Some specifics to the murder was that he wasn't just shot once, he was shot multiple times. And a bullet finally went into his lung. And he felt the pain of that. And felt his life flash in front of his face while he slowly died as his lungs filled up with blood. My brother was a mechanic. He was full of life. He was loved by us. He was loved by his family. And there's not a day that goes by that we don't think of what we're missing. The kids he might have had that might have carried his legacy on that we have nothing of him. I don't know if you can truly feel the loss and the grief unless this has happened to you personally. My mom always said, the loss of a child was a hole in a heart that could never ever heal. When she passed away, she was a very depressed person because that person wasn't in her life anymore. It carried on to us, her grief and loss. It carried on to our grandchildren. It affected every moment and every second of our life, and it still does. The holidays, the vacations, the memories that we no longer have. My brother was full of life. He loved to drive race cars. He was an awesome mechanic. He worked side by side with my dad. It's just when we went to trial, it was life without parole, and we was able to slightly move on knowing that justice will be served. But, then it was 99 years, and then the 99 years turned into another number. And we just feel, he served left a little over a quarter of his sentence and less than half of his sentence if we go back to the 99 years. I still, we have moved on. We've learned to live without my brother, all of us. And we have to carry his memory in our children and our grandchildren, but we just feel that at least half that sentence should be served. That is fair to us. Because it was tragic, it wasn't one bullet, it was multiple bullets that was being shot until a life had ended. It was violent, and you shouldn't kill people. It's, you know, it's not something that we do. You know, we live in a society where we shouldn't be doing it, and also the family feel that he should at least serve that his sentence. You know, and I hear, you know, about this life and all the people he's changed and, you know, and all, but, you know, we never had that opportunity. We never had that chance for my brother, you know, to make a change in his life, you know. It's just, it's gone, you know, and it's just a grief and a loss that, you know, it's really deep. It affects every second of our life. Thanks so much.
Thank you for being here. All right, Mr. Stewart's, case was assigned to Mr. Barra.
Mm-hmm. Yep. Mr. Stewart, we had a lot of people talking about you and for you, but we haven't heard anything from you. This is your shot. Go ahead and tell us why you think you would be a good candidate for parole, what you've been doing.
All right, thank you. Thank you for allowing me this opportunity. First and foremost, I would like to just extend my deepest heartfelt apology, you know, to the Brock family for causing them so much pain. And you know, I pray that they'll understand that my heart goes out to them, and I take full responsibility for what I did. The crime that I committed, it was senseless, and I'll never probably be able to live that down. But everything that I have done it with Mr. Brock in mind, because I don't want to be a person who continue to hurt, but I want to be a person who serve and help people, so we won't make any more victims. As for this, the thing that I've done since I've been incarcerated, I was doing these things even before I had an opportunity that I was going to ever be released from prison, because it was in that moment that I realized that what I did was wrong. When I took Mr. Brock's life, I turned myself into the authorities. And I admitted to the crime. So I just want the board to just consider the things that I've done, and let the things that I've done speak for me, because it hurt me. I can't even begin to explain the pain it caused me, even having to go through all this again, and even having to think about the situation, because my intent wasn't to kill Mr. Brock, but it happened. And now that's something that I have to continue to live with, and I got to continue to try to help other people to not go down the same path that I done went down. I see so many guys or men coming to this prison with no direction, and so I try to help lead them in the right direction. I work with hospice. I'm a pastor in this community. I understand what it's like when people is grieving and they're hurting, because I'm the ear that they have to come talk to now. So I understand. I know how to express empathy. At one time, I didn't know all these things. If I could go back and speak to my 21-year-old self back then, I'll tell him to be patient, not to overreact, not to make permanent decisions on temporary feelings. A lot of things I'll go back and tell my younger self, so he would have to encounter these things. So thank you. Is there, you know, you sure?
Anybody else has a question?
I have a couple of questions I just wanted to clarify. We were looking at your record a while ago, and we see from maybe 2014, 2019, you went back and forth to Angola for several days or weeks at a time. What was that about?
We are going back on different conferences. That's when we used to have different conferences, and they used to bring all the peer ministers back, and the pastors back for those different conferences.
Okay, yeah, all right. That's kind of what I thought. We needed some clarification. Thank you for that. I don't see any other questions, so I do believe the panel is prepared to vote. Mr. Bylaw?
Listening to the testimony and reading the reports, you have done a great job in prison. You have completed a lot of programs. Hearing the pain that the victims still suffer. I'm going to go ahead and vote to grant your parole upon turning age 55. I think that's one of the points that maybe the victim thought would be a settling point, so I'm going to go with that.
Ms. Ledoux? Can we go into an executive session? We have a motion for executive session. I'll second. Can you call the roll?
Chairman Nelson,
Yes.
Daniel Byron,
Yes.
Gary Ledoux.
Yes. So we'll be in executive session for just a couple of moments to discuss confidential matters.
Bailey gets his wish and it goes to executive session. While that happens, let's stare at goats. We were a little bit in the Wayback Machine, so I can nudge us past that executive session. So this is the Simon Says Farms that I believe we visited last week to check on our goat friends. I kind of want goats when we get to the next place. I want them for milk production. Goat milk is good and good for you. Reminder, as of today, the Courtroom Files Morning Show here is also a podcast. You can find it on Apple Podcasts, Spotify, Audible, iHeart, all those places where you regularly get your podcasts. You'll be able to get it there. The last 2 days are already online, and they'll all go up a few hours after the show completes. So if you need a more portable audio-only version of this show, you now have access to that. Okie dokie, let's... I nudged them past the executive session. Let's see what they do.
Reconsider his vote. So I'll ask for his vote at this time.
All right. I'm going to still go ahead and vote to grant, but put the release date for May 1st of next year. That's as far as I can get it out there.
Mrs. Ledoux?
My vote is to grant parole with the condition that Mr. Stewart do not return to the parish of conviction, nor have any kind of contact with the victims whatsoever, as well as stay in the facilities and under the program for the parole project for up to 1 year.
All right, my vote today, I voted for Mr. Stewart at its clemency hearing. My vote today also is to grant the parole with the same conditions that have been outlined by Mrs. Ledoux, that he do stay with the parole project at least to his age 55. The proceeding is that his parole has been granted to the parole project.
Approved?
Correct me if I'm wrong, and I could be, but didn't we have 2 approves yesterday? So wouldn't that make 3 in a row? And wouldn't that be 100% unprecedented if true? Interesting. You know, we like we've said, we tend to harp on this parole board and what they do, but to be honest, they put themselves out there. They're very public about what they do, and sometimes they surprise. So there you go. Let's go say good morning to Judge Boyd.
All right, the court is calling 2023 CR 6932, State versus Johnny Guy Ramirez. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Anthony Cantrell for Mr. Ramirez.
Are you Mr. Ramirez?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Johnny Guy Ramirez who was placed on deferred adjudication in 2023 CR 6932 for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams on October 23rd, 2023 for a period of 10 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4. In Bexar County, Texas, the defendant Johnny Guy Ramirez did then and there fail to report to the supervision officer as directed for the months of January and February 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, ma'am.
We waive and abandon the remainders, Your Honor.
No objections.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. It is to revoke the defendant, adjudicate him guilty, and sentence him to 3 years in the prison.
That is correct, Your Honor.
Are you asking the court to follow that agreement?
Yes, ma'am.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Johnny Guy Ramirez, ma'am.
All right, why were you not successful?
Well, I lost my job, lost my wife, lost my kids, so I just didn't have no way of getting around anymore.
All right, when you say you lost your wife, lost your job, lost your children, what, they left you?
Yes, no, she didn't leave me, I called her cheating. Yeah.
Right, so here's the thing. If somebody is being unfaithful to you, that shouldn't cause your life to fall apart, because at the end of the day, usually what I've discovered, that person may have known you for only 10 years of your life, and you're letting your life fall behind, because of that.
Yes, I did, and then I raised my babies the whole time, and I just didn't keep it together no more, just losing her, my kids, everything. Remember my daughter was having brain surgery, remember? And she's going through it again. And the first one was successful, so not to go through it again, and it just killed me finding out that she was cheating and just let everything go. But
sometimes people will wait for us while we work our way through things, and sometimes they will not. I mean, it's just the way it happens.
I just killed me to lose my family.
All right, any objections to the court review and the court summary?
None at all.
All right. So let me just tell you what the court summary says, and this may be a reason why she decided that she was going to remove her star from you. It says that you failed to attend parenting classes, that you were calling the UA hotline, but you failed to submit to UAs, which usually means somebody's still using. And you were discharged from outpatient treatment due to continued drug use. And so that's why. And it says probationer did not respond to phone calls, text messages, mail letters, and reporting instructions left by field officers. Sometimes people practice tough love, and then sometimes people say, I'm done. I can't deal with this anymore. You're not trying to help yourself, so I'm not going to be a part of this. So I'm going to follow your agreement because you're requesting me to follow your agreement. Are you waiving your right to appeal?
Yes.
All right. The court is going to grant the motion, revoke, find you guilty, sentence you to 3 years in the prison, give you credit for any time served. And I'll request the therapeutic community. It doesn't increase the time that you're in custody, but if you take advantage of it and they accept you, Hopefully it can help you maintain your sobriety. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreements, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. When you're released from custody, if you can't find a sober support housing, transitional housing, or if you need to contact somebody to help you maintain your sobriety, if I'm still here, you come back here. I'll make sure that we find a place for you, okay?
Thank you. I would like that.
All right, good luck to you, okay?
Thank you, ma'am.
You're welcome.
Thank you, Judge.
Thank you.
So I'm not going to go there because generally speaking, I don't cover trials on this program because we only have 3 hours and it can easily go longer than that. So we tend to do shorter hearings. But of note, in Judge Wolf's court, you all know Judge Wolf is one of my favorites. We just can't often go there. He is currently doing the criminal trial of State versus Miller, and the subject matter is violation of sewage disposal. There is all sorts of different ways you can be in court, but I have to say, I don't think I've ever seen one where there's a trial over sewage disposal. So I'm going to keep an eye on that, and that could very well be its own video perhaps at some point. Let's go back to Judge McNally.
This is Edward Nykel, P42017, on behalf of Joshua Edward O'Day, who's present and to my left. State your name, sir.
Joshua Edward O'Day.
All right, does he stand mute and waive formal reading, or do you want me to formally arraign?
No, he waives a right to have a formal reading, and will stand mute to the charge.
All right, I'm gonna enter a not guilty plea. I'll give you $1,000 personal bond, no alcohol, no illegal drugs. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I will give you, he has no priors I'm seeing, and it looks like from the citation, it was a .11, correct, allegedly?
That's the, what my understanding is. I haven't had any discovery yet, but yes, that is, I believe, what's.
Okay, we'll set it for a pretrial. What do you have for me, Lisa?
August 28th at 8:30.
August 28th, good, Mr. Nykel?
Check that. That's 2 weeks out. I did just, we stipulated to a discovery order, Judge, yesterday, and that was sent to the police department. So we're, hopefully we'll get discovery pretty soon. I would hope that 2 weeks would be fine.
If not, you guys can stip to adjourn another couple weeks, okay?
August 28th at 8:30, would we say? And are we via Zoom still?
As long as he's with you.
All right, very
You can show up
good.
in person or with him via Zoom.
We appreciate that, Judge. Now, does he need to come to the courthouse at all?
No, no reason.
Okay.
Okay?
All right, thank you. Have a good rest of the August. We'll see you at the end of the month.
These days are going, the years are going fast, aren't they?
Years and months and days and hours. I just had a birthday yesterday, so.
Good, happy birthday.
Yeah, I'm sure you'll be catching up to me soon. And
Right, very, very soon. Take care. Thanks.
Bye-bye.
All right, Brandon Scott Chandler. It's Mr. Chandler.
They're on Zoom.
Oh, okay. It just, he has Mr. Weinberg. Okay. Morning, Mr. Weinberg. How are you?
Good, how are you today, sir?
Good. Your appearance?
Aaron Weinberg on behalf of Brandon Chandler, who's sitting to my left.
Okay. How much more? This is going to be the third pretrial, right?
My first one,
Oh, you just got retained? Okay, good enough. All right, good enough. All right, your name, sir?
Brandon Chandler.
August 28th, is that when we're going to do, Lisa?
Yes, 9:15.
Is that good with you, Mr. Weinberg?
I don't know how quickly Trent will get me the discovery, so I guess I don't want to waste. Is there another date after that, or is that the next, is that the only available date?
I mean, he's just sending you a police report, right? He should have that over there. If he doesn't, you bring it up.
Looking for the body camera and the video from the in-car too.
Oh, and Mr. Bologna, see if you can get it to him. I mean, it's July 17th. I don't mind if we go out 2 more weeks. That's fine. You want to go 2 more weeks? Lisa, you got a date like in early September?
September 11th at 8:30.
September 11th at 8:30. Is that good with you?
He's on the way.
Yes.
Okay. I'll just encourage him. He's coming in here right now. I'll encourage him to quickly get that to you, okay?
Connor, is it, I think he said someone could maybe email the discovery order to me. Do I need to come out there and grab it?
Oh, no, we'll send it to you.
Okay.
I signed it, by the way, so
I'll email it.
yeah, we'll email it to you. Mr. Bologna, your appearance?
Anthony, at the city attorney.
So you're gonna be able to get the body cam to him pretty quick?
As soon as that's signed, it will go to the Trenton PD and they'll fulfill it.
Perfect. I'm adjourning this till September, so
Okay.
we'll go from there. So he'll
Ron?
email you the discovery order and what else?
One quick, what's the latest we could have it on September 11th for the court for the pretrial?
What, you want a later time?
If possible, yes.
I don't have a problem. Can you do 11?
Yes, that'd be perfect.
We'll make it at 11.
Thank you.
Okay, see you then, Mr. Weinberg. Nice to see you.
I see you too. Thank you.
Good luck, sir. Rise of Gibraltar LLC. Do I have anybody here for them? 25G82776. Yeah, I think we need to start putting down that they need lawyers on these. I'll talk to you about that, Lisa. Your name?
Ralph Thomas.
I can't let you appear on behalf of the corporation, okay? Not on something like this. So you're gonna have to file, you're gonna have to hire a lawyer, unfortunately, but that's the rule. So you are the resident agent, and are you the president as well?
Member, yes.
Pardon?
Member of the LLC, yes, a partner.
Okay, you need to hire a lawyer. We'll give you a date in a couple weeks, okay?
Sounds good.
August 28th, Lisa?
Yeah, August 28th at 9:15.
At 9:15, okay?
All right, thank you.
I wish you well. Good luck. Thank you. Penny Pruitt, you can go right down the hall and they'll give you a notice, by the way, sir. Penny Melissa Pruitt, did you call, what's the hold up with them? You know?
She's a detective in an interview.
Penny Melissa Pruitt, 25T645951A and B and C. Your name, ma'am?
Penny Melissa Pruitt.
All right, you're charged with possession or use of a controlled substance. You're also charged with false information to an officer and license invalid. You have the right to a lawyer. If you want one, I'll give you one. Do you understand that?
Yes, sir.
Okay, we'll set you up with an attorney. You can go right out in the hallway, okay? And then either way, you're coming back in front of me, all right? Okay, after you speak with your lawyer, you and your lawyer will come in here.
Okay.
Is Rachel Marie McGarrett here? 25G306253. I'm not gonna make him wait much longer. Did they tell you when they're gonna be done with the interview?
She had no idea.
Can she have,
She just said she's in an interview with somebody.
well, they need somebody to stand in.
All right, see if I can get somebody else.
Your name?
Rachel Majero.
You're charged with failure to pay fines and costs as ordered, balance owing $375. And if you plead guilty, or if you're found guilty,
Just have a seat.
you could have your probation, your 771 status revoked, conviction entered, and you'd be subject to a 90-day jail term. Do you understand that?
Yes.
Actually, this would be a first technical violation, so you can only get 5 days if you plead guilty or if you're found guilty. Do you understand that?
Yes.
All right. And I'm just telling you the maxims. I don't want you to get all worried. You just sign the advice of rights and read and understand the rights. If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes.
You have the right to a lawyer. I'll be happy to give you one at public expense. Would you like a lawyer?
Yes.
Okay. I'll enter a not guilty plea for you. We are going to have you speak with the lawyer today.
Okay.
And I'm entering a not guilty plea, and then either way, you're coming back in front of me with the lawyer after you speak with him. Do you understand that?
Yes.
All right. Do you have any questions?
No.
Okay. Good luck. See you in a few minutes. Thank you. Priority base policy, what?
Mr. Nykel logged back in. I'm not sure why. Do you want me to bring him in?
Do I still have the file?
Which one was that?
Chandler, was it? Let me take this
yeah.
first. Priority Waste LLC, 25T6460226A and B. Your name, ma'am?
Good morning, Your Honor. Elizabeth Tremblay appearing on behalf of Priority Waste.
I'm sorry, I'm kind of discombobulated right now.
It's okay. Me too.
All right, so you're going to plead to, you're authorized to enter this plea, and you're entering a plea to overweight with agreed upon fines and costs of how much? $3,000, right?
$3,000, yep.
And then the expired plate to be dismissed?
That is correct, Your Honor.
All right, to that charge, overweight, responsible or not responsible?
Responsible.
All right, please accept. It's fines and costs $3,000. I'm dismissing the expired plate, pay by September 14th, okay?
Okay, and we do have one more, Your Honor. One other file.
People Against Priority Waste LLC, 25T64615, A, B, and C. Okay, there we go. Your name again?
Elizabeth Tremblay appearing on behalf of Priority Waste.
All right, so same thing. You're authorized to enter this plea. You're going to plead on overweight with agreed upon fines and costs of $1,000. And
That
then
is
the other two remaining charges will be dismissed. True?
Yes, Your Honor, that's true.
The charge of overweight violation, responsible or not responsible?
Responsible.
All right. Count one, plea to overweight is accepted, $1,000, pay by September 14th. Counts 2 and 3 are dismissed on motion of the prosecutor. You're all set.
Thank you, Your Honor. Have a good day.
Thank you.
So this is the part where I tell you all what a wonderful person Michael Groff is and how you should all subscribe to his YouTube channel because his content is amazing and he's such a great guy and his voice is just incredible and he's really good at what he does and he should have more subscribers than me, but he doesn't. And oh, by the way, ignore all of the teenage comments and stuff you just put in the chat. So, anyways. Oh, golly geez. Now what? See, I'm all something elated now. Let's go back to Louisiana. Let's try that again.
And we have the parole project, Mr. Myers, your mother, Miss Mary Sampson, and your daughter, Onyx Addison, and all of whom will be speaking on your behalf. First, Mr. Banks, let me just read some identifying information into the record. Mr. Banks, you're classified as a 4th felony offender, currently serving a life sentence. You were sentenced, you're serving a life sentence for attempted possession with intent to distribute marijuana, possession with intent to distribute marijuana, and as a habitual offender, possession with intent to distribute cocaine. You have a parole eligibility date, which has passed. It's October 27th of 2022. You do not earn good time. So is all that information correct, Mr. Banks?
Yes, ma'am.
All right, Mr. Banks, tell us why you're there, why you're in prison, serving a life sentence for dealing and using drugs. What have you done since you've been in prison that you would make you believe we should vote favorably for you?
Well, I had a better insight on life since I've been incarcerated, and I've accomplished my ISET. I have taken several vocational skills as well as other self-help programs. And if given the opportunity, I would like to give back to society what I've taken away. I've grown to know that in selling drugs, I've destroyed a lot of people's lives. Not only my family, but people in the community as well.
Right. And we'll get a little more information from you when we do our interviews. But first, let's hear from Warden Rings. Is there anything you can tell us about Mr. Banks?
He's been housed here since 2016. He's currently in medium custody. He doesn't currently have a job due to some duty restrictions, health concerns. He does have numerous vocational classes that he's taken. He has his high school equivalency. He hasn't had a disciplinary report since 2019. I guess the only thing I could say negative about Mr. Banks is he's got numerous aggravated sex offense write-ups, and throughout all of his classes that he's taken, I don't see where he's even attempted to get the sex offender treatment. That's about the only thing I can say negative about it.
Okay, well, thank you. We appreciate it. Mr. Myers, we'd like to hear from the Parole Project.
Yes, good morning, Kerry Myers with Louisiana Parole Project. We're here on behalf of David Banks today to support his parole. Mr. Banks is serving a life sentence, as you stated, for nonviolent offenses. He would have had a parole hearing in 2022, except that his health, he was actually hospitalized. He had to have surgery. He had to have a second surgery earlier this year, but he is on his way to recovery. Also stated was that he has multiple programs, both vocational and cognitive programs. Mr. Banks, and talking to him just earlier this week, certainly recognizes the fact that while he was not a user, he dealt drugs for money, and he understands fully that the harm that caused to his community and the people that he sold to. He has a supportive parole project. He has a long-term residence here in Baton Rouge. He'll be also connected to us locally because of that. We're prepared to help him through this transition with employment, with the skills that he needs, with the life skills, financial, technology, social norms. He'll be evaluated by our social workers. He's been a member of AANA while he's been incarcerated. He'll continue to do that once he is released, not because he used, but because he understands that his drug dealing harmed people's lives, and he can relate to that. He can actually be a positive force through that. So we'd ask this board to consider Mr. Banks today and grant his parole.
Thank you, sir. Could we hear from Miss Mary Sampson, please?
I'm here.
Yes, ma'am. What would you like us to know about your son?
I believe that in the time that he's been incarcerated, he's learned a lot. He's worked to develop skills that could help him to grow on the outside, and that the things that he's done, I noticed that the growth that he's made in the time that he's been incarcerated has helped him to change a lot of positive in his life. He's changed a lot of attitude about how he felt about what he was doing. And the fact that he really want to make a difference in his life and the lives of others. That has been a real help for me in knowing that he's really ready to take responsibility for himself and the support that he will have on the outside that he can lean on and depend on, helping him to grow at this point. I'm here to support him. He has other family members that are here to support him. His sisters are available as well as other family members. I'm very proud of the fact that he's worked to enhance his life, to grow, and to make positive changes for himself. Is there any particular questions that you would like to ask me other than that?
No, ma'am, thank you very much for sharing those remarks with us. We'd at this time like to hear from Miss Addison.
Good morning.
Morning. Go ahead, tell us what you want us to know.
At this time, I would love to speak on my father's behalf and advise that I miss him. I've been without a father my whole life. I'm sure you all can see his criminal history. And this has been a tough battle for us. We've been working to try and get him on the right path, and I believe he has made progress. He's done the things that it takes in order to show that he's ready for society to accept him. I'm willing to accept him. He has a home to come home to. He has stability here with us here in Louisiana or in California, whichever he chooses to decide where he wants to be. I just hope that you all could give him just one more opportunity to see what he can do in order to enhance the world here outside those walls.
Okay, thank you so much. Mr. Banks, your case has been assigned to Mrs. Ledoux. Would you answer her questions?
Mr. Banks,
Yes, ma'am.
what year did you go into prison this last time?
2007.
2007.
Yes, ma'am.
It looks like you woke up and started taking classes around 2013. Is that correct?
Yes, ma'am. Well, I taken a few, I was taking a few classes at Simpson, at a few satellite camps. I took a few classes there, and the few that I was able to take when I was in Angola as well, due to the life sentence that I had, I was very limited to the programs that was offered. So I had to take what I could take at the time.
So with the life sentence, why were you trying to take classes?
Well, I felt as though that I needed to better myself. I seen that I had destroyed some people. I've destroyed lives, selling drugs. And that's not the way that life was meant to be. Took me a minute. But I see what I done. And I know that I did wrong. I look back and I see children without shoes, without food. And I say to myself sometimes, I might have been that person that took that from them. And I know that I was wrong for doing so because I wasn't raised that way. I was never raised that way to be that person. So I had to make a change in my life. I had to take some type of stand for myself and understand that life is not just surrounded by you. You have other people that you're hurting as well. So I needed to just take a look at myself and just try to bring out what's
In your opinion, I mean, I can read, I have sentencing minutes and I can read what's on the paper. Why do you think that you got a life sentence for nonviolent? I mean, let me just be honest. I mean, I see lighter sentences for murder. So why do you think that you got a life sentence for nonviolent drug charge?
I can't really answer that. Only thing I can say that I've been selling drugs and I've had numerous chances. And I feel as though the judge gave me that at that time. He felt that's what I needed. Right now, I need, because it gave me the opportunity to realize that I'm sitting here with a life sentence. Not knowing if I ever get out. But I need to make a change within myself. Where I'm at, right here, right now. So, through the years I've been incarcerated, I seek those changes through programs that I've taken.
It may have been a good thing for you to have been in with that attitude, knowing that you're looking at a lot.
Yes, ma'am.
Okay. So your health is improving, you said?
Yes, ma'am. Thank you, sir.
I don't have any further questions.
So, are you addicted to the money?
I was addicted to the money. I was addicted to it. The money was something that I used for a crutch. And I thought I was doing the right thing, but I knew deep inside me, I knew I was wrong. And
Did you ever do a paying real legal W-2 job?
Yes, ma'am. I've always had a job. I've had plenty of jobs. I have plenty of skills. I'm a cement finisher, roofing, cook. You know, I have plenty.
You just wanted more.
I've been working all my life. I wasn't raised this way.
Well, I hear your mom, listening to your mom, I know that's the case. You just wasn't satisfied.
No, I took the street life on my own. My mom never smoked. I've never seen my mom drink. Nothing.
How many children you have?
I have two.
We heard from one. Do you have your daughter? Do you have a relationship with the other child?
Yes, ma'am. She's in Houston, in Texas, rather.
So you have California and Texas? Family? You have family, Louisiana, California, and Texas?
Yes, ma'am. Yes, ma'am.
All right. I don't see any other questions. I think what I think about you is that we'd have locked you up a long time when you first got arrested, your very first offense. We wouldn't be looking at you today, probably. Might would have got your attention back then, huh?
It's been a big eye opener for me. It's really happened.
Yep. All right. I think we're prepared to vote. Mrs. Ledoux.
Mr. Banks, you can well imagine the scope of sentences I see before me in this job, and life sentence for nonviolent drug is, you've been in over 16 years. My vote today is to grant parole to the parole project until such time as you make long-term arrangements. I'd like for you to stay there at least 9 months. And then you can make some long-term arrangements where you feel like it's best for you to be. And I would encourage you to continue with AA and NA once a week, at least for the first 6 to 8 months, to keep your mind straight on why you went to prison. Okay?
All right.
I'm going to concur with Mr. Ledoux, but add the condition that you stay out of the high crime areas. And if you don't know where they are, ask your parole officer. They probably still the same as where you used to go. And that you complete 2 days community service per week until you're gainfully employed. If you have a job, you don't have to do the community service work. If you're unemployed, you're gonna have to do the community service work. We just don't want you out there with nothing to do.
Yes, sir.
All right, Mr. Banks, my vote is the same, to grant you parole with the special conditions that have been spoken by my colleagues. You understand all those conditions?
Yes, ma'am.
Like to you, sir.
Thank each and every one of y'all for accepting me.
You do realize that on a life sentence, when you're paroled, if you mess up, you go back to life.
Yes, sir.
Okay.
Approved?
Ashley, the keeper of the calendar, mark down this day, the day that the earth turned upon its side, the day that the sun exploded, the day that cats and dogs started living peacefully together. That is now 4 approves in a row. And I'll be honest, there's part of me that wants to say we'll never go back to Louisiana again just so we can end on a high note. I'm shocked, I tell you. Absolutely shocked. Let's do something different. I think we've been here once or twice before, but not often. Let's go to the great Commonwealth, rather, of Kentucky. This is Judge David Williams.
Okay, will you interpreters raise your right hand? You solemnly swear or affirm that you are authorized in the Commonwealth of Kentucky to give services as far as interpretation. Both of you do that, and you will honestly do that. Thank you. Lower your hands. Commonwealth of Kentucky versus Javier Dominguez, is that correct? 25 CR 0029. Mr. Dominguez, were you born in 1995?
Señor Domínguez, ¿nació usted en 1995?
9 de diciembre.
You need to.
December 9th.
December 9th. He needs to speak up, so tell him it's a voice activated mic.
Hablar en voz alta para que el micrófono se active y podamos oírlas.
Do you have a social security number?
¿Tiene número de seguro social?
No.
Okay,
No.
we're here for a pretrial conference.
Estamos aquí para una.
What does the Commonwealth have to say?
Fidelity plea.
Okay. A motion has been tendered that says you wish to enter a guilty plea today. Is that correct?
¿Desea declararse culpable el día de hoy? ¿Es correcto?
Sí, por supuesto.
Are you currently under the influence of drugs or alcohol?
¿Está bajo los efectos de alcohol o drogas?
No, ninguno.
No.
Is this plea freely and voluntarily given?
¿Se va a declarar culpable y libre y voluntariamente?
Perfecto.
Are you the same person we just identified in 25 CR 0029?
Acusado en el caso 25 CR 29.
Is your judgment impaired today in any way?
¿Su capacidad para decidir está afectada de alguna manera el día de hoy?
No, ninguno.
No.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Y está conforme con el asesoramiento de su abogada. Yes.
Okay. Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about your case?
¿Usted está completamente informado de su caso?
Sí, claro.
Yeah.
Yes.
You understand that you do not have to enter a guilty plea today.
¿Va a declararse culpable el día de hoy?
You have certain rights under the Kentucky and United States Constitution.
La Constitución de Kentucky y de los Estados Unidos.
Before I can accept a plea, I need to know that you understand those rights.
Ya, necesito saber que usted entiende esos derechos.
I'm going to go down through the rights, and at the end, I'm going to ask you if you understand.
Le voy a preguntar si usted comprende.
If at any time you need a moment to step away from the podium and consult with your attorney and interpreter, you just ask for that opportunity.
Intérprete puede hacerlo.
Okay, you have right not to testify against yourself. No one can make you say anything.
Puede obligarlo a decir nada.
You have a right to speedy trial by jury,
A un juicio por jurado sin demora.
the right to be represented by counsel at your trial.
Por abogado en el juicio.
You have a right to confront and cross-examine all witnesses called to testify against you.
Digo que vengan a declarar en contra de usted.
The right to produce evidence,
Derecho a presentar pruebas.
the right to call witnesses in your favor,
A testigos en su defensa.
the right to appeal this matter to higher court if you lose,
Este caso ante un tribunal superior si usted pierde.
and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges.
Porque usted es culpable más allá de una duda razonable.
You understand by entering a guilty plea today, you give up those rights.
Declararse culpable, usted renuncia a todos estos derechos.
You understand that?
¿Entiende eso?
Sí.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law.
A fiscalía, pero también podría imponer una pena más alta que de la recomendación.
Prior to accepting your recommendation, I will order a pre-sentence investigation report to be done by probation and parole.
Una investigación precondenatoria que realizará la Oficina de Libertad Condicional.
In the event that I do not accept the Commonwealth's recommendation
La recomendación de la fiscalía
and decide to impose a harsher sentence,
a imponer una pena más alta,
you have a right to withdraw your plea and go to trial.
a retirar su declaración de culpabilidad e ir a juicio.
So I cannot give you more than you've agreed to
No le puedo dar más de lo que usted ha acordado,
unless you agree to that change.
a menos que usted esté de acuerdo con el cambio.
Who's doing the Commonwealth's recommendation? Ms. Gordon Anderson, will y'all move to the left just a little bit so she can get behind the microphone? Okay, now listen very carefully here.
Upon a plea of guilty to burglary second degree,
De entrada ilícita con fines ilegales en segundo grado,
the defendant shall receive a sentence of 5 years to serve.
el acusado recibiría una pena de 5 años a prisión.
The defendant shall receive credit for time served.
También el acusado recibiría crédito por el tiempo que ya estuvo en la cárcel.
The Commonwealth opposes probation and shock probation.
La fiscalía se opone a la libertad condicional aprobatoria y a la probatoria libertad condicional por shock.
Okay, you move back over here.
Regresemos aquí.
Is that your understanding of the Commonwealth's recommendation?
¿Es esa la recomendación que usted había entendido que iba a hacer la fiscalía?
Sí. Sí.
Are you pleading guilty because you did commit the acts charged in the indictment?
Porque usted cometió los cargos de los que fue acusado formalmente.
Perfectamente. Acepto todo porque
Yes, I accept everything.
Okay. Now, knowing your constitutional rights, as I explained it to you,
Los derechos constitucionales que le expliqué,
is it still your desire to
es su deseo
continue with your plea and allow the court to fix your punishment?
continuar adelante con la declaración de culpabilidad y que el juez le imponga la pena.
Do you understand that after entering a plea of guilty, any future convictions of felony can be enhanced as far as the penalty?
Si cometiera más delitos graves, las penas podrían ser cada vez más altas. Yes.
Okay. Now, I accept the agreement. I will order a pre-sentence investigation report.
Que se realice
You will be sentenced on September 16th.
Y la fecha para la imposición de la pena o sentencia será el 16 de septiembre.
Okay, the probation and parole
La
individuals will meet with you and they will have an interpreter on the phone to take the information. That's how y'all do it now, is that right? Okay. And that information will be used to determine how I handle your sentencing.
Para determinar cómo se impondrá su pena, su sentencia.
Is that your signature on the document?
¿Es la firma de usted la que está en el documento?
I've already asked you that once. So.
sí.
Yes.
Okay, well, thank you very much. And
Bien.
the probation parole will be to see you in the next few days. Thank you. Now, Madam Clerk, or is there any other need for an interpreter today or anything? Okay, the interpreters may be excused. Thank you for your help here today. Have a safe trip home. Stephen Brown.
Have to look in the.
Y'all need a second or two more with him before you leave, since you got an interpreter now.
No, girl, we're just letting him know.
Okay, that's good. Well, then move it over that way then, okay? Are you Stephen Brown?
Yes.
Good morning. This is 23 CR 0063, 24 CR 005, 25 CR 001. You're here on 2 probation revocations and a pretrial conference. Is your year of birth 1980? Last 4 digits, social security number 0. What does the Commonwealth have to say about Mr. Brown's case?
I believe Mr. Davis and I conferred about this morning. We thought this was going to be on the docket in October, I believe. And so we had.
I think my calendar says September.
September, I'm sorry.
Yeah, we agreed to give my investigator a little time to look at it.
So I would ask it be set for September 5th for negotiation and September the 18th for pretrial. And if it's not resolved, then I'll ask for a
September
trial.
16th,
Yes,
isn't
sir.
it? September 16th?
It's 18th, I believe, Your Honor.
No, 16th. It's been moved, yeah.
On a Tuesday?
Yes.
16th.
Oh,
not
well,
marked
that
out.
may present a problem for me.
Okay, well, you can get back with Mr. Stockton. You can still go on the negotiation day.
Okay.
And if you want your client present on the negotiation day, you'll need to submit a transport order, okay?
Yes, sir. Well, can we just set that for the October date? I already have, I'm supposed to be in other counties on the 16th.
If that's okay with your client, it's okay with me.
That's
Okay.
fine, please.
It'll be fine. Okay, we'll do it for October the 16th.
Thank you, Your Honor.
Okay, and you still want him there on negotiation day on the 5th, or?
Yes,
That
please.
way it gives
And
some
yes,
intervening
sir.
time. Okay,
Yes, sir.
thank you very
Thank
much.
you, Your Honor.
Have a safe trip.
Well,
Okay, what else do you have?
Your Honor, I have Chris DeWeese.
Is he out of custody?
He is,
I'll
sir.
let you go ahead and do that so you get on the road.
My apologies. Thank
No
you, Your
problem.
Honor.
Commonwealth versus. I don't see him on here.
Chris
Yeah,
DeWeese.
Christopher DeWeese. Yeah, Commonwealth, are you Christopher DeWeese?
Yes.
Were you born in 1969? Last 4 digits, social security number 4272.
Yes, sir.
This is 25 CR 0028 for a pretrial conference. What does the Commonwealth have to say?
And Your Honor, I would just, if I may, I believe we're waiting test results. There's no test results in the file. If we could set this for the October date as well, I think
That'd be fine.
What's the negotiation date in October?
Be October the 3rd.
October the 3rd for negotiation and October 16th, your next court date. Both of those are conditions of your bond, sir, okay?
Yes, sir. Thank you, Your Honor. May I be
No problem.
excused, sir?
Absolutely.
Thank you, Your Honor.
Okay, Claude Kevin. Claude Kevin. Are you Claude Kevin?
Yes, sir.
Good morning.
Good morning.
Were you born in 1998?
Yes, sir.
Last 4 digits, social security number 0475.
Yes, sir.
We're here on 24 CR 0082, a motion for shock probation. You want to present?
Yes, Your Honor. So we had filed a motion for shock probation for Mr. Cabin. However, I've spoken with Mr. Stockton, and I think we have agreed to pass this until next month. That way that I could potentially line up a treatment program for Mr. Cabin.
Yeah, he was revoked because he wouldn't quit driving. If she can line up a treatment program where he's not required to drive anywhere, I might be agreeable to shock.
Okay, well, I won't rule on it today then. I'll leave it open. I'll take it under advisement. And we'll be back here on September the 16th.
Thank you.
Yes, Your Honor. Thank
Okay,
you.
no problem, yeah. Derek Graves.
I need that side. Right.
Commonwealth versus Derek Graves, 18 CR 0016. Are you Derek Graves?
Yes.
Good morning.
Good morning.
Were you born in 1994?
Yes.
Last 406?
Yes, sir.
Okay, we're here on a motion for shock probation. What do you have?
Yes, Your Honor. Mr. Graves, I believe, has been in custody since roughly April of this year. Mr. Graves is asking for the court to consider granting him shock probation
What
at
was
this
the underlying
time.
charge?
Your Honor, I believe that his,
What quantity was involved?
It was less than 2 grams, I believe. I can tell according to me.
and Your Honor, Mr. Graves is interested in participating in an IOP program if he is released.
The problem we've got with this case, Your Honor, is Mr. Graves, this is the 18 case. We've had 4 motions to revoke filed. The court has given him so much alternative sentence and we have, he's already got 2 years and 10 months, 10 days in credit because he's been in jail so much.
When's he for parole board?
He won't meet the parole board May of 26, so I guess he just got blocked. The reason he filed this motion.
That is correct, Your Honor.
But we just don't know when he's going to comply with probation based on his past record.
It's kind of, you think that's the reason they flopped him because it's non-compliance down through the years? And it's unusual.
It is unusual. I would have thought with as much time as he had in, they would have paroled him out. But they didn't. And well, I'm just afraid we'll be right back where we started. We probated him out. It'll be the 5th motion.
Well, here's the thing, if you can present the Commonwealth for some compelling reason that we ought to put his conduct in the past, like an employment record or something like that, or something he has, or some belief, he's not eligible for drug court, right? Is he eligible for drug court? Yeah, he's not eligible for drug court again. Okay, well, I'll take it under advisement. I'll give you an opportunity to convince the Commonwealth to go along with it.
Yes, Your Honor.
Thank you.
Thank you.
Yeah.
So as we move into the last half hour of the show, a reminder that we have Sidebar tonight, our live panel discussion, 8 p.m. Eastern, 5 p.m. Pacific. But I will be honest with you, we have not settled upon a topic for tonight yet. So do me a favor in the last half hour of the chat here, ruminate amongst yourselves some ideas of what we should or could talk about tonight. Stuff that we've seen on the channel, legal stuff that you've seen in the news, stuff that's on your mind with regard to courtrooms. Throw some ideas out there so we can toss them around and decide where we want to go tonight. But as far as going places, let's go back to Judge Boyd because I'm behind on my commitment for 9 to 11% more Judge Boyd today.
It's just on count 2. Good
morning, Judge.
Good morning. All right, let me do this. All right, the court is calling 2023 CR 7596 State versus Ariante Emmanuel Duran de la Cruz. Could I have parties announced?
Megan Galloway for the state.
Alex Sharf for the defense.
Could you have me move to the other?
And are you Mr. de la Cruz?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. de la Cruz, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
File stamp for a plea, please. State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count 1 and proceeding on count 2.
No problem.
No objection.
Did you review the admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand, and count 2, the state is proceeding on the offense of tampering with with evidence with the intent to impair as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering in this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
All right, off the record for a moment. Deputies, could you bring out Mr. Polk? All right, we're back on the record. Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand that?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. There's a $2,000 fine to be probated. The state recommends deferred adjudication, and there's to be restitution to Ethan Reyes. Did you understand that to be the plea?
Yes, ma'am.
Defense?
That's correct. Yes.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Ethan Reyes, and the cognitive thinking course. Did you understand those were recommendations from the state? And the court does not have to follow those recommendations.
Yes, ma'am.
To count 2, how do you plead?
Not, consecutive. I forgot the word. Not
Guilty, not guilty, or no contest?
No contest, ma'am.
State, any evidence?
State offer states 1 in attachment.
No objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right. After reviewing state's exhibits one and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We can judge. The only issue would be whatever the restitution amount is. And so, like, when I conferred with the state, they didn't really have a figure on what the restitution is. We could go forward on sentencing in general, but if there is, whenever they come up with the restitution amount, if we could have a hearing on that before that is imposed by the court.
So are you still employed at this location?
Yes, ma'am. I'm also in HVAC school as well.
All right, state. On this case, do you all have any objection? I'm assuming he's still a bouncer. I don't know if they trained them or not. From reading, it appears that
Oh, no, that's a contract. I do like HVAC and electrical. I'm no longer.
It does more construction.
Yes, ma'am. I'm no longer security.
No. My question is, according to this, he was a bouncer.
Yes, ma'am.
It appears that people, they would probably hire me as a bouncer if I just came in and said, hey, do you need employment? And they say, yeah, we need a bouncer. Okay. And send me out with no training. So my question is, state, do you have an objection to his continuing to be a bouncer at this club? I mean, at this place, what is it called? Private?
Yes, Judge. I mean, I would have an objection to that, but my understanding is that nightclub or whatever it is was closed down. So I'm not sure if he's still working for whatever.
He's not working as a security guard since this incident. He's doing.
Because while you're on probation, you're not allowed to have any weapons. You
Yes,
understand?
ma'am. Yes, ma'am.
And the name of this club was PRIVAT
Correct. Your
with no E. This is what happens when we stop spelling things correctly. And what time is this alleged to have occurred?
in the early morning hours.
Nothing good happens after midnight, and now really nothing good happens after 10.
Yes, ma'am.
Okay?
Yes.
Do you have any, thank you. Do you have any children?
No, ma'am.
So what do you do in your spare time?
So I currently work and I go to school. I'm in a trade school. So I do that.
What are you doing with your trade school?
HVAC now.
Okay. All right, court is going to sentence you to a $2,000 fine. That will be probated. Proof of employment within 30 days, no employment as a home health care provider with minors or as security. There's to be regular reporting by Zoom or in person, regular random UAs. There's to be no contact with Ethan Reyes. And I need a restitution hearing in 30 days. What date?
Is it
30 days.
I can do September 8th.
All right, state, on September 18th, you'll need to have proof of restitution.
Yes, Your Honor.
There's to be 200 hours community service restitution. That'll be waived if you obtain your trade school certification.
Yes.
If you don't obtain that, then you need to give me 200 hours. There is to be the State, do you want the cognitive thinking course? It appears that it was just somebody being placed in the position as a bouncer and they didn't receive any training.
Judge. Yeah, we're not requesting that, but just I would request then that he not be employed as any type of bouncer or security guard because he's not commissioned.
All right, thank you. There's to be field visits 1 time per month for 5 months. And there's to be the anger management course. Probation, is there anything else? Thank you. All right, the state is asking for 10 years deferred adjudication. Defense.
Your Honor, and I told Mr. De La Cruz that if he wants to, we don't have any objection to whatever the length is.
Well, do you want 10 days outside the agreement is a request for 10 years deferred adjudication? Do you have any argument for or against the 10 years deferred adjudication, or do you want the court to order 10 years deferred adjudication?
I would argue that 5 years deferred adjudication is sufficient. I believe Mr. De La Cruz, once he gets through school, that he's gonna whiz through his deferred adjudication. He's gonna pay. He's gonna work. He's not using drugs, not drinking, and that he'll be done with it early, and will probably provide or submit a request for early termination. We'd ask for 5 years.
All right, the court will sentence you to 8 years deferred adjudication. Is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement? Yes. All right, do you need a transfer?
So no, not entirely. Because of this whole entire situation, I became homeless, so I'm just living out of my friend's house right now.
Okay,
That's his mother's address.
That's my mother's address.
okay.
So I just wanted something that was actually legit, like on paper.
All right, if you ever need a transfer, just let the court know.
Yes, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Oh, yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you. Have a blessed one.
Oh, thank you. You too.
Thank you, Your Honor.
Welcome.
Julia, thanks for stopping in. Appreciate you doing that. Hope you're having a good day at work today. I know that you had some stuff going on, so appreciate you taking a few minutes to spend with us. We only have about 10-15 minutes left, so we'll just continue to ride with Judge Boyd here. I'm sure she'll have somebody up here again in just a minute. Reminder again tonight, sidebar 8 p.m. Eastern, 5 p.m. Pacific on YouTube and X and Rumble. We simulcast to all 3 of those places for that show. And yeah, it's a lot of fun. The 4 of us get together. We have good conversation. The interaction is great, and would love to have you there. So if you haven't checked out the show, be sure to do that right here on this channel on YouTube or on X or on Rumble at our channels there as well.
Angel Montoya. Are you all ready to proceed?
Yes, sir.
All right, where's Mr. Montoya? Hi. Hi. Court is calling 2022 CR 0054 State versus Angel Montoya. Can I have parties announced for the record for the state,
Rick Pena for the state of Texas.
for the defense?
Attorney Bill Simmons for defense.
And are you Angel Montoya?
Yes, ma'am.
Did you review the document entitled State's Motion to Enter Adjudication of Guilt and Revoke Community Supervision and State's Motion to Supplement Pending Motion to Enter Adjudication of Guilt and Revoke Community Supervision?
Yes, ma'am.
Are you the same Angel Montoya who's placed on deferred adjudication in 2022 CR 0054 for the offense of injury to a child bodily injury on February 13, 2024 for a term of 6 years? Is that you?
Yes, ma'am.
All right, State.
Yes, Your Honor, off of state's supplemental pending motion, adjudication of guilt and revoke probation. Violation condition number 4. In Bear County, Texas, the defendant, Angel Montoya, did then and there fail to report to the supervision officer as directed for the months of April, May, and June 2025 in violation of condition number 4.
How do you plead to that? True or not true?
Okay.
I'm sorry?
True, sorry.
Additionally, Your Honor, on the state's original motion to enter adjudication of guilt, state will waive all of those violations.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court would could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, and
Yeah.
that is for the motion to be denied to allow the defendant to apply for felony drug court. Should she be accepted to that, then fine. Should she not be accepted to that, then alter and amend conditions of her current probation to add SATIF followed by SATIF aftercare.
All right. Why isn't she reporting?
Your Honor, is the court inclined to hear testimony? Because I have one witness as well.
Yes, I want to know why she's not reporting.
If I could, and then we'll call her, Judge.
Sure.
Okay. If I could call Leslie Banderas.
Right. Oh, could you raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Leslie Banderas.
All right. Counsel, you may proceed.
Ms. Banderas, how long have you known Ms. Montoya?
All right.
All her life. And you're familiar with her legal situations that she's been involved with, correct?
Yes.
Okay. And you've got a unique knowledge of that based on some of the organizations that actually, community organizations, the numerous community organizations that you're involved with, correct?
Yes.
Like, what are some of those organizations?
I have an organization, it's called Homies and United Network.
Mhm.
How we deal with the formerly incarcerated and their families by, providing resources or guidance into the right direction. I also work with TOPS, and I also work with a national organization called All of Us Are None.
Okay. And in terms of your working with TOPS, what kind of work do you do with them?
With TOPS, basically, we just get together and try to provide the resources that the individuals that we're working with needs. Therefore, if I can't provide it, then of course I guide them to like TOPS, they're one organization, maybe with housing and stuff like that. As far as we deal more with like teaching the formerly incarcerated and their families on their rights to vote. And then again, we do a lot of mentoring as far as like, against bullying for the kids and stuff like that.
And you work a lot within the community, correct?
Yes, we recently just did a formerly incarcerated march that came out on TV. We did it, I think, on May 31st, was it the last?
And the reason I'm asking this is that so that you have some understanding of Ms. Montoya's, what she's dealing with.
Yes,
And so, you admit you deal with the formerly incarcerated.
yes,
When she had gotten up, she was on a parole, is that correct?
yes,
And, but she did, bottom line, you deal with a lot of people in these situations, correct?
yes,
Would you say that she was putting her best foot forward to try to be in compliance with her parole and the new probation that she had received?
yes, from what I saw, she was completing, going to classes, and correspondence with her probation and her parole officer. We were even getting visits. She was getting visits to homes. So she, as far as I know, they were good visits, as far as I'm going over there. I didn't really, like, she volunteers. I have her, whether it's passing out flyers or helping us organize events, things like that. I mean, just nothing. She wasn't like the party goer or anything like that as far as I saw.
And so, and when she was doing the outpatient treatment, she was going to all of those classes, correct? Because you were kind of.
Yes, I was giving her rights to.
Yes, giving her rights to them. And to believe she was only 2 classes away from completing that intensive outpatient
Yeah,
Or-
yeah, I know one of them she did complete. I'm not sure if she was still needed to complete more.
And in terms of the parenting classes, she actually completed those?
Oh, yes.
Okay. And when you were talking, and the other thing, just when you were talking about the financial resources, again, it was tough for her. She got there, but there was some where she was making an attempt to do everything that she could. Would you agree with that?
Yes.
Okay. I'll pass it with you.
Any questions?
Just a few questions. I'm sorry, I didn't catch your name.
Leslie Banderas.
Ms. Bandas?
Banderas.
Balderas. And how long did you say you've known Miss Montoya?
I've known her all her life.
All her life. So since you were children, you guys grew up together, I guess?
I'm her mother.
Oh, you're her mother. I'm sorry. I didn't hear that part too. All right. So you being her mother, are you aware of the issues she's been having with substance abuse?
Yes, I've been aware as far as what she was I guess smoking.
Okay, how, to your knowledge, how long has she been abusing drugs or smoking, as you say?
I'm not even gonna lie to you, when my kids didn't even start messing up their life after they moved out of the house, after the age of 18.
Okay, so
She's always had I've never had problems with her in school, anything like that. She graduated, even had a scholarship to go to college.
Mhm.
She was good, so.
all right, so after adulthood is when these issues started to come about. And what did you do to try and help her with those issues?
Well, like I said, when she moved out is, well, basically when she started doing all that stuff, the thing what I did was like pull her away, you know, like I said, she volunteers a lot. I have my own organization.
Okay.
So come on, let's go do this, let's go do that. And again, because she has kids, so my grandkids, I want them to see, you know, hey, this is a positive way to go, like I even offer counseling.
Okay.
Because we also offer that for free as well.
Okay. Have you yourself specifically seen her smoking marijuana or any other type of drug?
No,
Has she ever appeared under the influence to you?
no, I just want to clarify, like, with this, what she's dealing with right now, I haven't. Okay, like, when she moved out of the house, back when before she even got in trouble, there's been occasions that I've seen to where, yeah, you know,
Okay, so
doing that, but.
so in the past, you have seen her smoke marijuana, but recently you're saying you haven't. Is that
Yeah,
what you're saying?
recently don't have,
Okay, so when was the last time you saw her use marijuana?
before she went to prison,
Okay,
and this was
Right.
years ago.
okay. And since then, you're saying you've been trying to help her get that issue resolved, correct?
Yeah, like I said, I was the one giving her the rights to
So,
the classes and picking her up from the classes. Okay, like, what do you have to do? Like, Georgia, you need to call up people. They need my number, the probation officers, parole officers, they all know my number. They all call me.
okay.
We always correspond. Like I said, they go to the house.
Did you also help her check in with probation when she's supposed to?
Her probation officer, like I said, would call me because they switched all the time.
Right, yes, they,
So every time they would switch, they would call me. So I would be in correspondence with them. Like if they felt that, oh, you know what, Angel, then she needs to come and see me for this, whatever, they would call me if they couldn't get over it, because she had her own phone. I provided that.
Sorry to
Yes, when
interrupt.
you-
So, sorry to interrupt. You're recommending that she be continued?
correct.
All right, so here's my question for her. Either she wants to be on probation or not. She's not going to be released today. She's going to safety. If she doesn't want to go to safety, then she's going to be revoked.
Oh, I believe the recommendation was SATIF, or no, safety.
It's sad, but based upon the stipulations that were entered into and what she did, obviously there are major drug issues, and this is more than just, I think, can be taken care of by SATIF, because let me just tell you the reason why I say that. She's looking at 10 years in the prison. So she has some choices to make. Either I use drugs, and potentially could go to prison for 10 years, or either I don't. And she made the choice, I'm going to use. So that tells me that her thought processes are not where they should be, and that she's in the throes of her addiction. So I'm going to give her a choice of whether she wants to be continued on probation and go to safety, or whether she wants to go to prison.
What is that, CP?
It's an inpatient treatment facility at the prison.
Oh, they provide housing, because me,
Yes, they
you know,
do.
what, like I said, the organizations that we do, we just basically feel, they need help regardless of what.
No, they're gonna give her help.
Regardless of what the case is, every individual needs help.
No, they're gonna give her help if she wants it. So let me have you step back and I'm gonna ask her what she wants.
Your Honor, would that, so we're saying that there's no option for her to at least be interviewed by a felony drug court?
Felony drug court is probably not gonna accept her. I'd say 98% because of these charges and the underlying facts that are in these stipulations. So you have a choice. If you want, and these are the only two choices, there are no other choices. So there's no third choice. One, I can continue you. I will continue you and sentence you to safety. Or two, I will revoke you and sentence you to 5 years in the prison.
Okay, but that interferes with my parole that I'm already on. And I'm good on parole. I go to all my classes, I pass all my drug tests, even some of the drug tests that I've come out negative as far as on probation, I've passed on parole. I'm getting help. I go to behavioral therapy, I go to therapy, psychiatrist, I'm on my depression, anxiety pills and everything like that. I'm on a mood stabilizer now that I'm in Bear County, like I
See, these are things that people need to do when they're not in
was
custody.
doing that before custody. I have proof that I was doing that before custody. I went to university, I got into behavioral classes, I got in therapy. When I went to my TAP evaluation, I asked for the intensive outpatient drug course because I told her I felt like I needed the help.
And if I may, Judge, we did verify that with probation. She was only one class away from intensive outpatient, but I think the big thing is that they wrote her glowing reviews. They said she was doing a very good job. That's in the notes. It's also reflected in the court summary.
Any
in terms of
objections
that
to
she
the
was
court
doing-
reviewing the court summary?
No, Your Honor.
All right, in reviewing the court summary, it says that once she just found out she had a warrant, she didn't report anymore.
Yes, Your Honor, I believe, but it's also under the, if I could see it. What I was just specifically referring to was in their justifications. Just that specific language about.
All right, so what I'm telling
despite
everybody.
Their great attendance in the IOP program.
All right, so this is what I'm telling everybody. They 99%. There's a 1%, maybe they'll accept her in the felony drug court, but there's a 99% chance they are not. What I'm telling you is she has a choice. If she would like for me to revoke her, I will sentence her to the 5 years. If not, then, I'll send her to felony drug court, but I'm telling you, felony drug court is not going to accept her. There's a 99% chance they won't accept her. If they don't accept her, she's going to safety. So those are the choices. There are no other choices.
Yeah, I understand this.
Can I have 30 seconds, Judge?
Yes. Yeah, just give me one moment. You need to remove that cap and remove the shades. All right, so what are we doing?
Can I ask one question? Judge?
Sure. Counsel?
Yes, Your Honor. If we could, about how long do we think the felony drug court referral would take? Because
They'll probably have it done by next week.
there's some questions to ask in terms of whether or not the safety would result in her parole being revoked because it's treated as if, and I would ask the court too, it would be treated as if she's being sent to prison, which would revoke her current parole. That's a question that I would like to know, because I'm not something at the front of my thoughts. I'm not sure if that's true.
If that's true and it results in that, then
Yes.
we can always bring her back. All right, the court is finding violation of condition number 4 true. Court will deny the motion. alternate amend conditions to include in custody, a referral to felony drug court, if not accepted, then safety.
Yes, Your Honor.
All right, thank you. Thank you.
All right, friends, we leave it there for today, at least with the morning show. We will be back tonight again for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. If you have not joined us there before, please do. Number one, because it's a show that we're trying to grow because it's new, but number two, it's fun. You get to kind of see things in a little bit of a different way. We're not flipping between courts. We're just talking out court kind of stuff, and it's a good time, so be sure to join us. Other than that, we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members, so please do join us tomorrow as well. And be sure to check out our sponsor, Aura. There is a link for them in the description. It is aura.com/TCF. Again, you get 2 weeks for free when you use that link. It is totally worth it. And every time you guys sign up for the free trial, it is in support of this channel. Plus as well, quite honestly, you're helping yourself. So be sure to give them a look. But go have yourselves a great day. Hopefully we see you this evening. In the meantime, take care. God bless.